Looking to make sure I've got all the members that have joined us at this point. So if we could please have the gallery view. Thank you. All right, just want to make sure. Mr. White, Ms. Willis, waiting, Ms. Markovich is there. All right, I think we can start then. We have a quorum, so we'll get on with the opening remarks. So, bonne soirée à tous et bienvenue à cette rencontre du Comité de dérogation pour la Ville d'Ottawa. Welcome everyone to this meeting of the Committee of Adjustment of the City of Ottawa. The Committee of Adjustment of the City of Ottawa is essentially a quasi-judicial tribunal that's appointed by council to make decisions on certain kinds of applications under the Planning Act, and the ones that everyone's always most familiar with are consent applications and minor variances. So my name is Anne Tremblay, and I am chairing this hearing this evening, but I am accompanied by other members of the Committee of Adjustment. So I have with me this evening, Mr. Colin White, Ms. Kathleen Willis, Ms. Julia Markovich, and when we do have another member who will be joining us, and when he arrives, we can, there we are, Mr. Hindle, your timing is perfect. So thank you. I'd also like to say, just introduce very quickly the wonderful committee staff that make all of this happen for us. Without them, we would be literally lost. So I'd like to introduce our Deputy Secretary Treasurer for this evening, who is Ms. Cheryl Williams. We also have a number of coordinators that makes the magic happen. So Ms. Emily Byers, Ms. Mandy Nguyen, and Ms. Maddie Harriman Fernandez. So thank you very much to all for being here. Take note, this session is being video conferenced. You can access both the agenda and the video if you want to go back and hear anything again. Just go through the city's Committee of Adjustment web page and you'll be able to find the right links to what you're looking for. So before we begin, a couple of opening remarks regarding what we can and we can't do as a quasi-judicial tribunal. So we have essentially no authority to deal with aspects of an application which isn't squarely before us. So we really can only deal with what we are being asked to consider. So nothing to do with, for example, if the massing of a building is of concern to you, but there's no zoning, relief from zoning that's required for that. That's not something we can really talk about or need to talk about because relief isn't being, no approval is being sought by this panel. We also can't talk about any pollution issues, whether it be, for noise or litter or property maintenance in general, and of course, property values, which is often one that's of concern. We also don't talk about any of the development that's being proposed as if it has occurred. So nothing to do with any illegal prosecution or prosecution for illegal construction, pardon me. We don't consider that at this table, essentially. Also, we will at no time entertain any negative comments about either the applicant, the agent, neighbors, or anyone else who wishes to take part in these proceedings. And then finally, sometimes during the course of discussion, we realize that either an additional minor variance or greater relief to a minor variance is required. And if that happens, we have to adjourn the item on those, have to adjourn that item essentially to allow for a recirculation to ensure that the public, which is regulated through the Ontario Planning Act, gets the notice of what, in fact, or accurate notice of what it is that's being proposed. So, as part of the statutory public information requirements, each applicant is required to post a sign on the property and then to file a statutory declaration with the committee confirming that sign posting. And so what we've found during our pandemic time online is that, in fact, it's been easier to do oral affirmations or attestations, if you will. And so I think for all of the applications, if I'm not mistaken, those that will have to be done where the items will be heard. So with respect to quorum, if we lose quorum for whatever reason, due to technical difficulties, we then will simply try as much as we can to restore the quorum before we in fact decide to adjourn whatever remaining items are on the agenda to the very next meeting. So okay, so and I think that's it. So luckily we have not had to do any of that in the close to 2 years that we've been online now and doing our hearings. So another couple of things. I know there's a few members, or one member in particular, that may need to leave early this evening, and also a member who may stay off screen during discussions, only because that condition is better for that member. Doesn't mean that they're not listening or can't take part in this vote, because on those occasions you will see all the members visible on the screen. So I think I can go now to the process, which I think is probably the most interesting to most folks that are listening to us at this point. So we tend to. So there's an agenda that you all saw at the outset, and the agenda tends to really only follow the order in which applications came in, save and except for the adjourned items. When there's adjourned items and they're set to another date, they're often put at the end of the agenda. So tonight we have a couple of those that are, in fact, we have 3 of them, I think, on our plate for this evening. So what happens then, since we've been online, is we'll call the application. It can be, and I can vary that order depending on whether there's to be a presentation, whether it's a complex application. I can vary the order, and I think we will be doing that this evening. So we've also adopted a bit of a fast track route, and I think for the most part, I would tell you 90% of the applications this evening are going to be a fast track, which means that we will not require a presentation from the agent or the owner, but we will open it directly up to the members of the panel to ask questions for clarification. So if a presentation is required, I'll let you know. We'll give you your time to do that, and then we'll go to the panel members for questions. Once all that is done and the panel is satisfied that they've got the information they need, we'll open it up to the public for input. So at that point, I do have a speakers list. Where I have names, I'll go to those first. And then I'll open it up to anyone else who has an interest in the application. So don't worry if you're not on the speakers list. All you need to do is raise your hand as we proceed, and we can bring you in. That said, the people who are on my list, I have their municipal address. I know who they are. We've got the documentation. So if you are coming forward, the only thing I'll ask you to do is to open up with your first and last name, and I may need you to spell your last name, and then to also give your municipal address. So after that, the floor will be yours, and then the committee members might have questions for you. So in that case, we'll try and get the questions to you and get the answers back, and then proceed that way. Once we've gotten through everybody, we're going to close that public portion, and then the committee members have a chance to deliberate on any new evidence that they'd heard during the course of discussions. Once that's all done, we're ready for a decision. And so the panel has, or the committee has, pretty much a tradition of giving, in a lot of cases, an oral decision that's then followed up within 10 days of the hearing with a formal written decision that provides all of the rationale. But we give that information often as part of the discussion when we give an oral. The cases where we don't give an oral is when we have a reserved application. And that means that we may have a lot of new information, new evidence that's provided by either neighbors or their agent in some cases. And in those cases, what we do is we will adjourn the overall meeting, and then we reconvene right after to essentially deliberate on that new information. And then we make a decision before we essentially get to finish our work this evening. And when all of that happens, as I said, so every application that's dealt with essentially moves forward, and they're all subject to this 10-day requirement where we need to get a written decision out to anyone who has an interest. So, and with that, once you have it, of course, there is a 20-day appeal period at which time you can appeal the committee's decision to the Ontario Land Tribunal for a fee. So We're on to the business items. First thing, any declarations of conflict of interest by any of the members for either of the items for tonight or any of the items before any of the other panels. Mr. White, go ahead, please.
Thank you, Madam Chair. With respect to the three items, actually, three items on panel one, item 2, 661 Keenan, and then on panel 3, items 5, 6, and 7. I guess that's 4 items. I wanted to declare interest on those matters. I periodically do subcontracting consulting work with the agent on that application. In fact, I am currently involved in one project that he is handling at the moment. Not the 3 that I've mentioned here, but I do wish to declare interest on those 3 items.
All right, thank you very much, Mr. White. Anyone else from the panel? Okay, I believe we have confirmation of some minutes, and I may be looking. Yes, so I do need a motion to adopt the minutes of January 12th. Do you have a motion? Mr. Hindle, seconded by Mr. White. So we have adopted the minutes for January 12th at this point. And I think the next order of business then is essentially to go to the adjournment requests. And we have quite a number this evening. So let's start with applications number 2 and 3 for 2 David Drive, looking for Jean-Philippe Tella. Sometimes it takes a couple of minutes to, I see that they're there. It just takes a few minutes to get them from being in the audience onto the panel. So that's what the little delay is all about.
Can you see me?
I can't see you, but I can hear you. Can you turn on your video?
Yes.
Perfect. Good evening.
Good evening.
Good evening.
Okay, so I have you down as the agent for this, for the applicant. Is that correct?
Actually, it's my wife, and yeah, we both part, but her name is on the line. Yes.
Okay, so you're aware that there's a request for an adjournment on your application for this evening?
Yes, I did talk with the city staff, and she was mentioning some section that we need to go through.
Some section. All right. Maybe looking for a little bit of help from, and I think it's Ms. Cully. Hello, how are you this evening, Ms. Kelly?
Good, thank you. How about yourself?
Thank you. Very well, thank you. Can you just give us some quick insight then as to the request for adjournment?
Absolutely. There are still revisions required to the plans that have been submitted, and I'm going to be working with Mr. Tala to make those revisions in time for the next hearing that would be available to be scheduled for.
All right, so you would be amenable to a March 2nd meeting adjournment?
Yes.
Ms. Cully, you got enough time? All right. Okay, that's what we're looking for. So, Mr. Tala, are you okay with the March 2nd date?
Okay. Yes.
All right. Questions on the adjournment by any of the panel members? Yes, Ms. Willis.
Just looking at the report that was accompanying the application, just a suggestion that when it does come back to this committee, assuming it does get adjourned, that there be additional evidence provided to the committee that will provide information on what the lot fabric and the streetscape look like so that we can determine the merit of the application based on the character of the neighborhood.
You got any questions, Mr. Tala, about that?
If I could get a little more clarification, I could. Because my understanding from the city staff is that when we outside of mature neighborhoods, we don't need the street character.
No, so it's not that, Mr. Tala. What Ms. Willis is getting at, and we encounter this sometimes when people who are applying before the committee don't necessarily have the experience. We need, so the committee expects planning evidence to this. So there's 4 tests under the Planning Act that we have to go by in order to determine whether or not something should be granted or should be refused. So
Yes.
we need planning, we need some planning evidence to help us with that decision. And so what Ms. Willis is suggesting is that if you could provide some lot fabric information, tell us a little, whether it's photographs or look for yourself what you think makes it a good fit, what makes it compatible, how does it relate to the rest of the neighborhood? That's what we're asking you to do.
Yes, and we did prepare that in the presentation but the presentation will be for the next hearing. But we did a presentation, or we prepare a presentation showing that character, the research that we did for the neighborhood.
So we don't see those presentations. We review the file and all of the material that's brought in on the file. So you need to give us that information individually. Then what the city does is that they provide it to us on an electronic platform, and we can go and get it, and we can go and look at it before we get to the hearing.
Okay.
Okay.
I will do that. Yes.
All right. Thank you very much. That would be really appreciated. Any other comments, questions from the members of the panel? No? All right. Anyone in the audience like to speak either for or against this proposal to adjourn this application to March 2nd?
Madam
Okay.
Chair, this is Nancy Wilson from the City View Community Association, and we're agreeable to the adjournment.
To the adjournment to March 2nd? Works for you? All right. All right. Well, thank you, Ms. Wilson, for that. In that case, I don't see anybody else come forward. So, members of the panel, all those in favor and of adjournment of this application to March 2nd, the decision is unanimous. So we will see you in a couple of weeks.
Thank you.
All right. Thank you so much.
Okay, have a good day.
You too. Have a good evening.
Good.
We're at evening already, imagine. Okay. I'm just making some notes for myself. All right. The next application up for adjournment is 21 Groupe Street. Looking for, on this one, Mr. Paul Cooper. Mr. Paul Cooper. I'm not seeing his name come up, so can one of the coordinators let me know whether or not he is in attendance? There
Yes,
we go.
it's just coming up now.
All right, thank you. I need to be more patient. Mr. Cooper.
Hello, I'm here. Can you hear me?
Yes, we can hear you. We don't see you though. So is it possible for you to come on camera?
Yes. Yeah, it's just the prompts are slow. There we go. There I am.
Excellent. Excellent.
Good evening.
Good evening. Oh, good evening to you too. So Mr. Cooper, you're aware that there's a request for adjournment on this application?
Yes, I am. I've been speaking with planning staff with reference to the request.
Okay. And can you just summarize very briefly the purpose of the adjournment?
The purpose of the adjournment was to amend the wording of some of the variances requested, in particular variances C and D, relating to the relationship of the proposed garage addition to the front lot line. And so, those were the issues in question.
All right, thank you for that. Ms. Cully, can I have you back, please, for a minute? So Ms. Cully, my question to you then is, it looks like there's a recirculation that would be required as a result of this, because I'm seeing the numbers change to be greater relief from the zoning bylaw. Can you confirm that for me?
Yeah, Madam Chair, that is our understanding, yes.
All right, so we would need a recirculation, and now I'm actually looking to Ms. Williams, just to confirm the date that we could get this circulated through back to the public and then back before the committee. So what date would work the best for that?
Through you, Madam Chair, if we could have documents in by Friday, we could accommodate the application on the March 16th hearing.
All right, so Mr. Cooper, would that work for you? Can you get all the materials in by this Friday?
It certainly is possible. In fact, the changes are already agreed upon between myself and Christina. And I've amended the site plan accordingly in terms of demonstrating the dimensions that relate. And I thought for that reason, I thought perhaps there was an opportunity for us to be able to push forward with the application today, even though there is a technical change to the magnitude of the variances requested. I've reached out to the community association and the neighbors that we discussed to make sure that they're appraised of the changes and to see if they would support the notion of moving forward today. And I have received confirmation from a neighbor as well as acting as chair of the community association that she supported the idea and had no concerns about the changes to the minor variances. I don't know if the committee can have regard for this, but I'm hopeful because ultimately it's going to lead to some delays to my client.
So Mr.
Otherwise,
Cooper, we don't have much choice here. It is great. You heard my comments, my opening comments, where if there's greater relief from the zoning bylaw, we need to adjourn the item and then we need to have a recirculation. That's because that's essentially the way that we have to proceed on this. We've had legal advice on it from the solicitors, the legal services from the city. So that's how we need to proceed. So unfortunately, we're having to adjourn. So the earliest date we can give you is March 16th.
okay. If there's no other option, then we'll accept the adjournment date.
All right. Any questions from the committee in the interim on this adjournment? No? Okay. Anyone in the public out in the audience have any concerns or would like to speak to the committee either for or against this request or this proposal for adjournment now to March 16th? Okay, I'm not seeing anybody come forward. So with that, members of the committee, all those in favor of the adjournment to March 16th? Ms. Markovich, are you in dissent? Okay.
Sorry, I'm in favor of the adjournment. Pardon me.
All right, thank you. So with that then, for the record, the decision is unanimous. We are adjourning this item to March 16th. So we'll see you in a month, Mr. Cooper.
Okay, thank you.
Thank you. All right, so we're on to 100 to 130 Colonnade, and I'm looking for Nikita Jariwala. Do we have the agent? Yes, I see. Okay, coming up. Good evening.
Good evening.
So my understanding is that in fact, this came in very late and it came in from the agent side that there's a request for adjournment on this application. Is that correct?
Yes, that's correct. We received the planning report just yesterday afternoon. So that's why there was a bit of a delay on that.
All right. So can you just summarize the reason for the adjournment, please?
I'm actually going to pass it off to Debbie, who is our lawyer, and she will go ahead and provide that explanation.
All right. Go ahead then, Ms. Bellinger.
Thank you, Nikita. Thank you, Madam Chair. I'm here on behalf of 100 to 130 Colonnade Road. My address is 50 O'Connor, 3rd floor. We're requesting the adjournment because we received conditions from city planning staff through the committee just yesterday, and we believe we can resolve those conditions. There are some issues with them as drafted that require further discussion with the city. We've contacted them, explained in a preliminary way the concerns through regional, and Nikita's team did that. And we've procured a meeting with the city staff for early March. So we'd like to request an adjournment for 2 months. Whereupon we'll come back on with those 2 issues resolved.
2 questions for you, Ms. Bellinger, then. So our understanding was that there was the issue was condition number 1. So I think what I'm hearing from you is there are additional conditions for which there is some concern. And my second question to you is why 2 months?
My understanding is the conditions related to not only whether there would be MOE certificate of approval issues related to servicing easements. Second issue related to a bus stop. It is a site with a history. It's the original Gandalf campus with existing site plan approvals, existing servicing and existing easements. The application is intended to do a cleanup on some easements that weren't conditioned in the original severances. And in my experience, whenever we tread into the territory, with no disrespect to engineering stuff at the city, but when we tread into MOE territory, I can't guarantee that we can come to a quick resolution on those. We may have to have some consultations with MOE and with more particularly the consultants for the owner. So that's why we're requesting 2 months in caution so that we're not back before you before we've had a chance to fully understand the city's concerns and to respond to them in a way that's acceptable to both parties.
All right, thank you very much. Questions from the committee? Ms. Wallace.
Yes, just a question to make sure that I understand this correctly, that this is an old site plan, it's an old existing development, it's fully serviced. You're just cleaning up some technical issues with regard to easements, and this proposal does not involve any sort of development of the site whatsoever. Is that correct?
Yeah, through the chair, yes, I'm responding. That's exactly correct. It's the original severances of the sort of T-shaped parcels were reserved the required access, surface, pedestrian, and vehicular easements. There is existing servicing in the same roads that comprise those easements, but the easements did not include the servicing over those specific parts. We're not looking, we haven't created any new parts. We're not filing for site plan approval. All we're doing is cleaning up the title. Nevertheless, we do wish to go back and make sure the city's on side that in the context, perhaps these conditions are not appropriate.
So just again, is it just condition 1 you're concerned about, or are you concerned about both conditions?
It's my understanding from the client that we want to speak to the city about both conditions.
Both of them?
Yeah, the bus stop, when I say both of them, I'm referring to the bus stop and the potential MOE issue on servicing. We have no issue with standard conditions.
Sorry, the conditions that we're looking at pertain to having to do a servicing plan and also to enter into a joint use maintenance and common element.
Yeah, my apologies through the chair. We have no issue with the joint use agreement that is contemplated, and in fact, we've drafted it. And we can even file that before the return date. That's a standard condition on shared property. So yes, in connection with the extension of the servicing easements, yes, we expect the JUMA, and I have no issue with that condition. It was a two-pronged issue with the city from my discussions with the client and their discussion with city staff.
Yes, if I can, from what I can see, in fact, the bus stop issue is actually under additional comments as opposed to the conditions.
Thank you for that clarification.
Madam Chair, I'm just wondering if, oops, sorry about this. I'm wondering if we can hear from staff about the rationale behind the requirement for condition 1, given what has just been explained, that there is no development being proposed here. Oh, just a sec, I'm sorry. I ended up somehow in the middle of a FaceTime call with my granddaughter. My apologies. Yeah, so if we could hear from staff about the rationale for including this condition when there's nothing being proposed here.
All right, go ahead, Ms. Ramirez. Anticipating, that's good.
Thank you, Madam Chair. When certain services cross, there is a requirement for an ECA. And so in this instance, there is services that cross property boundaries. And so that's why the requirement, that's why the condition is included.
But is that not pertaining to the installation normally of new services?
So I see the applicant's lawyer has her hand raised, but my understanding is that when there are services that are proposed to cross and when there are services that cross, that an ECA is required.
So that was not done then, Ms. Ramirez, at the time that the site plan was approved?
There's a very old, I guess, information available to engineering staff at the moment. And so some of those services do cross. I believe the water definitely crosses over the property boundaries. And there are, I want to say, storm as well. And so infrastructure services has requested that condition for the services.
All right, Ms. Bellinger, maybe you have more information.
Thank you. Yeah, at the time the original severance was done, and at the time the original site plan was approved, which is still a registered and binding site plan, and at the time the building permits were issued for the existing properties which are serviced through the roads, these requirements were not the same as they are today, and in fact I don't believe had evolved to that point at all. I believe these originated out of Walkerton, is my experience with the requirements. We're not here to debate whether those requirements apply tonight, but we are satisfied that the services that are there, we're not proposing services to cross property lines that we're creating tonight. The services are there. They cross existing approved property lines. All we're trying to do is to extend the easements that exist to serve those properties to include the services that exist and were approved by all required authorities at the time, so that the title is cleaned up. In effect, whether or not MOE had anything to say about these services crossing lines back in the 70s when the Gandalf campus was developed, they do in fact cross, and we're not changing anything. We're just cleaning the title.
Okay, so it seems to me though that there's enough history here that it might be worth it to have that more fulsome discussion with engineering staff and to really get this straightened out. So, okay.
But I do appreciate the comments through the member of the committee, Ms. Willis, and thank the chair for the indulgence on an adjournment request for this discussion.
Well, we just want to make sure we're doing the right thing. You know, I mean, for us, it's often better to just deal with the application if we can. So that's why we like to explore it. So thank you for your background, though. That's been very helpful.
Thank you.
So, Mr. White.
Thank you, Madam Chair. I have to admit that I'm very familiar with this site and the history behind it. Site plan approval process at the former city of Nepean, since I was involved. I was a member of planning staff at the time, and I'm very familiar with the site plan approval exercises that we went through in Colonnade. The site plan agreement, and I'm glad to hear that the former city did not miss anything with respect to the approvals that were required at that time. There is a site plan agreement registered on title, and Ms. Bellinger is very correct in pointing out that that's binding on title. Successors and signs notwithstanding, there are conveyances here, etc. I'm looking forward. I have no problem with the deferral as it's requested by the applicant, but I'm expecting to hear some fairly significant explanation as to the necessity, why staff sees the necessity for that condition 1 to be imposed. Thank you.
Looking forward to that when it comes back, if I'm hearing. Okay. Make sure
we will ensure there's a fulsome explanation. Thank you.
Excellent. All right. That said, anybody else from the committee before I throw it out to the public? No? All right. Anyone in the audience want to speak either for or against this request or this proposal for adjournment to, and we didn't talk about a date, but 2 months gets us to April 20th. Does that work? All right. So April 20th, anyone with any comments one way or the other? All right. Nobody's coming forward. So with that, members of the panel, all those in favor of the adjournment to April 20th. All right. For the record, that decision is unanimous. So we will see you back in 2 months, and good luck with your discussions.
Thank you,
Thank
Madam
you.
Chair and members of the panel.
Okay, so that was April 20th. Okay. The next application for adjournment is number 10. And it's for 3 Herald Place, looking for Mr. Smith. Mr. Smith. So you're here, that's good.
Evening, Madam Chair, committee members.
Good evening. So you're aware that there is a request for adjournment on this item?
I am, yes.
All right, can you just summarize briefly what the reasons are for that adjournment?
Yes, so I received a report from Planning Committee, Planning Department, where they had indicated that the current lot does not meet the minimum lot area, so not related to the development or the porch that we are sort of seeking to build, but just the existing lot is smaller than bylaw allows, and additionally, the wording of the original variance request for the new portion of the construction that we are seeking to undertake didn't include the projection of the stairs, the stairs to grade, which are actually an existing set of stairs, which we are not altering in mass or dimensions, but are sort of we'll be rebuilding as a portion of the construction. So there were 2 elements that planning had highlighted that they felt necessitated rewording or an additional variance.
All right, thank you for that. Questions from the committee on the adjournment, the requirement, and the purpose? Okay, just a quick question. Then I'm looking for Ms. Cully again, if I could. I have a very quick question for you. So we're looking. We need this adjournment essentially to allow time for circulation to add the minor variance so that we cover the bylaw requirement for recognizing a reduced lot area on this. Okay. Also, I take it then based on the adjustments that I'm seeing to variance B, that we're also asking for greater relief. So that in itself is also reason, if you can confirm, that we would need to recirculate.
Through you, Madam Chair, that is our understanding, correct?
All right, so we've got 2 reasons to do a recirculation on this. Okay, so and back to then Ms. Williams for a date. When would this be best to come back? I think I've heard this Friday is kind of the cutoff date for March 16th. So
Yes, it is.
all right. So Mr. Smith, do you feel that you would have sufficient time to, and I don't know where Mr. Smith went to. Oh, sorry, there you are. Sorry, my gallery. So people have just been moving around, and so I kind of lose somebody at once in a while. So, so Mr. Smith, if so, the idea is you would have to have all the materials required for recirculation in by this Friday. Can you make it, or should we be pushing this to perhaps the April 2nd meeting?
No, Madam Chair, I could certainly pull together the necessary materials for this Friday. I did, if I may, and you've been quite clear, from the outset and in your comments to Mr. Cooper that any increase in variance request basically mandates recirculation. So I won't try and sweet talk my way around that. I was sort of through discussions with staff that in some cases, if the alteration is deemed minor, committee may deem it acceptable to sort of make an amendment to the variance sort of on the fly. I'm assuming
it really needs to be. It's almost like just a roundup error. That's a technical problem, right? That's when we're talking about that. But in this case, it's very, very specifically in relation to the missed stairs in one case, right? And because of that, it triggers it.
Right.
So sorry about that. I would have tried for you, to honesty, if I thought that we could do a technical on that one, but I just don't see a
Right.
case for it.
I have some I have some nicely reworded variance proposals for you, but,
No, I think, and you need another minor variance in any event. And we could debate all night as to whether or not that one is, and we did. We had a lot of discussion as a panel as to, what's that, what the real intent is of that in the bylaw, but in any event, it is in the bylaw. So relief from it is required. And so a minor variance needs to be added. So we need a recirculation. And if we can do then the March 16th, we will do best efforts on that. And Ms. Cully, I just need your confirmation that you you feel that date also can work from your end?
Through Madam Chair, yes.
All right, perfect. Okay. Any questions for Mr. Smith? All right. Open to the public. Does anyone in the audience want to speak either for or against this proposed adjournment to March 16th? All right, I'm not seeing anybody come forward. So all those in favor from the panel? All right, for the record, the decision is unanimous. We are adjourning this item to the March 16th agenda. So thank you very much, and we'll see you in a month.
thank you.
All right, bye now.
Bye-bye.
Okay, the next one we're dealing with from an agenda standpoint is 6 Kitimat Crescent, and I'm looking for Mr. Bortolotti. We got Mr. Bortolotti in the audience.
Madam Chair, I'm also here. It's Greg Winters from Novatech, and I'm also representing Mr. Bortolotti. He's agent and applicant tonight, but he's also asked me to speak on the matter.
All right, do we have that for the record then, that Mr. Winters is speaking? I don't think so. On my, I just want to make sure for the record that we have. So just for the record, could you give us your municipal address so that we say that we've received that?
Absolutely. So I'm with Novatech, civil engineering planning firm at 240 Michael Copeland in Canada, Suite 200, and it's K2M1P6.
All right, thank you. You are on the list, as it turns out. It just took me a minute to find it, so that's okay. All right, great. And you are aware that there is a request for adjournment?
I'm aware that the staff report is asking for an adjournment, and as well as the RVCA have asked for an adjournment, yes.
All right, and can you just summarize very briefly the purpose of that adjournment?
So the city staff report is looking for a study so they can allow for reduction in the setbacks to water courses when a study is produced for geotechnical slope stability purposes, natural vegetation, ecological function, when it's in the presence of a floodplain, or demonstrating the impacts on fish habitat. And given the nature of the site in an existing very urbanized area with a very urbanized creek, we just don't see that there's merit for such a study at this point in time, and we wanted to be able to discuss that in full in front of the panel. And in addition to that, we reached out and I spoke with Mr. Lalonde at the Conservation Authority last week. I was only retained last week on the matter, and we had a brief discussion on it, and he had suggested an adjournment so that we could seek a revision to the application. But I've discussed it with my clients, and they're not interested in a revision to the application because they believe again that there's merits for the variance.
All right, thank you. I'm going to call Ms. Cully back. Sorry, Ms. Cully, I'm putting you on the hot spot a lot there tonight. So in our review of this, of your report and the application, the panel sort of identified two things here, not just the need for the report on number 7, because I think in your comments, what we sort of read between the lines, if not more explicitly, is that there is a pool that's being removed. And Mr. Winters, you can confirm that is part of the proposal, they're removing the pool in the backyard?
That's my understanding, yes.
And because of that, it may afford an opportunity to do a design that's a little bit different from what's being proposed, that would then would eliminate the necessity to in fact do the study at all, because we might be able to accommodate everything outside of that setback. Is that correct, Ms. Cully? We understood that?
Through you, Madam Chair, that is correct. That is what the planning report was intending to indicate.
Okay, and so the second step to that, and only when there's a determination that there's no other real opportunity to put the proposed development elsewhere, do you then look to the exception policies in the official plan? Is that correct?
Through you, Madam Chair, yes, that is correct.
All right. So Mr. Winters, we kind of see it as a two-pronged thing here tonight, not just the requirement for the study and whether the study has any merit, but rather what's the implications of removing the pool, and what opportunities are there to avoid even having to trigger looking at policy number 7?
So, Madam Chair, I'm not aware that the pool is part of this application, that there was some sort of a compromise being provided that we were looking at an additional change to the plans. That's completely unaware to myself. And maybe my clients can speak to that. I know that Mr. Bortolotti, Perry Bortolotti, who is the intended purchaser of this, or the owner of the house, he's online tonight. He can probably speak to that aspect. All I'm aware today is that there's a variance application to build an addition on the back of the house in this corner with proximity to the creek. And I'm not familiar with why removing a pool somewhere else on another portion of the lot is somehow offsetting that or making that issue go away.
I guess the opportunity is to explore it, Mr. Winters, is what staff is suggesting. So, Mr. Bortolotti is who? Which one of you is Perry?
We're both Mr. Bortolotti. I'm Perry, the property owner, and this is actually the architect. And so it has not been decided to remove the pool. That was in part of the planning stage. We're evaluating different proposals, but that's really not on the table. That has not been decided as of right now.
Okay, because that's in our report, it seems the intent is to remove the pool. Okay, I see there's a...
That was, yeah, go ahead, Gwen.
I was going to say just there's room for more discussion is what I'm seeing here at this point. So, okay, I think we understand the problem. I'm going to open it up to the members of the panel for their thoughts and their questions on this. Anyone? Mr. White.
Madam Chair, thank you. Yeah, the concept of the development of Qualicum area goes back a long time, in the 1960s. I think the application alludes to that, mentions that fact. The issue of the creek was addressed many years ago, a bit back in the late 70s, early 80s, when there was a substantial amount of bank stabilization that was done, gabion baskets, etc. And I think the applicant provided some photographic evidence in his submission with respect to that type of work that was done. At that time, the existing setbacks were recognized, ones that did not conform to the provision with respect to the 30-meter, was a 30-meter requirement, 15 meters from a defined bank, which would apply in this case. There were a lot of units in the subdivision. I think this one was done by Teron. There was a lot of units in the subdivision that did not conform to those provisions, but they were acknowledged in the zoning at the time that the former city of Nepean zoning bylaw was in effect. I don't think the issues have changed at all. I think any proposal at that time that was involved in encroachment into that 15-meter setback, further encroachment beyond what might exist or into the 15 meters. The policy was the same. There would have to be consultation and certain materials reviewed by RBCA and the municipal authority. So I don't think there's been any change here over the years, and I think these provisions have been in place for a long time. So I really don't have any problem with the concept of having to have the review done as is requested by staff and as is reflected in the official plan today.
All right, thank you, Mr. White. I actually am a little remiss because I think I'd like to hear from Monsieur Lalonde, because Monsieur Lalonde, representing the RVCA this evening, we do know that there are concerns from your end. Would you like a few minutes to just to explain those concerns?
Sure, if I may, through the chair. It is correct that we have asked for an adjournment. Based on the current proposal, we wouldn't be supportive of the application, but wanted to offer at least the opportunity to the applicant to revise the project to something that could be supported, and we'd be willing to have those discussions. I know we spoke on the phone prior to this meeting, and the sense was they had a plan and they wanted to bring that forward. We left our comments as is, requesting the adjournment to give them that flexibility if desired. As noted by Mr. Winters regarding the potential of bringing in a study, that can be done, but I am apprehensive of what the results and the position from the Conservation Authority will be, regardless of the findings of that study. We're looking at a lot that's already within the 30-meter setback, looking for additional encroachment. The setback that we're talking about is less than 15 meters from a water course. Even if they demonstrate the slope stability, I would still have concerns about additional encroachments. So rather than suggest go do the study and spend work on something, I would be remiss to say I don't know if we would necessarily support a reduction regardless.
All right, thank you, Mr. Lalonde. I really appreciate that perspective as well. Okay, any other questions from the members of the panel? All right, I'm going to open it up to the public. Is there anyone in the audience? I don't have anybody on the speakers list, but is there anyone who may have an interest in this item and would like to speak to a request for adjournment? I'm just going out to the public first, Mr. Winters, and then I'll come back to you. So just got to give it a minute to make sure that there isn't anybody out there, and I don't believe there is. I'm not seeing anybody come forward. Okay, go ahead, Mr. Winters, since we're closing the public portion.
Thank you very much, Madam Chair. The only record that I just wanted to mention that there was a number of submissions that were made by the public on this matter, including an email from Cal Kirkpatrick this evening that was sent over to Mandy earlier. So I just wanted on the record that there was some public representation on this, but it was put in writing.
Okay. We, at this late stage in the game now, you must appreciate that most of the members, we work full time. We don't get a chance to look at things that come in at the Wednesday of. I don't. It's, I'm trying to figure out the last minute what I need to be printing out sometimes. So no, didn't get that. So thanks for raising that. Okay. I guess the question I have next then is what date would make sense? So Ms. Cully, so seeing as there is a potential for which a study may need to be done and submitted and reviewed, it sounds to me like a May 16th date would be a little optimistic. Would an April 2nd date work, or an April 16th date be better? Is there any, or the other option is we can adjourn sine die and let it come back when some of that has been worked out. I guess I'm looking at this point to how much time you might be required. Ms. Cully, what would be reasonable in your mind in terms of ensuring that you get the material you need?
Through you, Madam Chair, I'm uncertain of how long that study would take to produce, so I cannot say with certainty what timeline would be best. Sine die might be the preferred, just to ensure that it's not heard again and adjourned again. But
all right, okay, that's fair enough. That's fair enough. And I understand the challenges with trying to estimate how much time it would take to do a study. All right. In that case, members, I'm looking to you for some thoughts on a sine die adjournment on this application. Any objections to that? Mr. Hendel.
Yeah, I think, Madam Chair, in this case, I would ask maybe the applicants to give a sense of when. It sounds like there's a lot of consultations to be done with Mr. Lalonde and others. So I would assume at least a month, if not sine die in this case I would be supportive of in this case.
All right. So, my worry is always if you go 2 months is sort of the outside. After that, you should be back into public notice, right? Because it's a lot to ask the public to stay on top of something that's been adjourned for 3 or 4 months or whatever it is. And that's why we use the sine die when it looks like the timeline is going to be too long. Mr. Winters, can you meet in terms of working out the issues and keep in mind that it might mean undertaking a study? Would an April 16th date work for you?
I'm going to defer to my clients on it. I believe, Madam Chair, that 1 month is going to be appropriate because I think the discussion is really around some of the confusion that we're having tonight between whether or not there was another alternative plan to be produced or not. So we want to at least be able to get that clarity. And I think that's going to be able to be done easily within the 1 month period. I tend to agree.
But if you need to do a study, Mr. Winters, so this is the issue. You need to do a study. Think about this because it's got to be, you got to get somebody, you got to have it done. You got to bring it in. They've got to review it.
Absolutely, Madam Chair. There's no way that we're going to be able to complete a geotechnical slope stability study. If those are truly required in COVID conditions, it's not going to happen. So we would need longer than that.
All right. Mr. Perry, Bartolotti, would you like to pipe in on a date?
Yeah, so Greg, what are we thinking? I mean, your organization is going to be involved in this as well, right? So on top of getting it through the city, so.
It's going to resolve around a geotechnical engineer being involved in it because we don't do slope stability analysis. So we'd have to seek out consultation with another engineering firm to be able to do that. So I would suggest that we go for the sine die and then come back at that point in time.
All right, thank you, Mr.
And the
Winters.
sine
That's-
die. What's the sine die represent?
Sine die means it's, and I'm gonna make sure they get this right, but it's a recirculation. It's like a restart of the application. It's a recirculation.
Oh,
So Mr. Bortolotti, what that is they put it on hold indefinitely, and then we come back when we believe that the issues have been resolved. But that would require a recirculation, renotice of the application to be able to get back on an agenda hearing.
That's right.
Yeah, I know everyone's busy in the coronavirus, and I guess also in speaking to what's her name, Christina, at that time, and unfortunately, when I contacted you 10 months ago, or 2 months ago rather, and you let me know that you don't respond to anything to the Committee of Adjustment a week before the sitting. And I was hoping that I'd hear something from you.
Mr. Bortolotti, I think really what I want from you now is, are you okay with a sine die, or do you want to specify a date?
I think we should try and pinpoint a date down. Sine die, it's a restart, isn't it?
Well, it's just a recirculation. So you will be asked to pay a recirculation fee. And Ms. Williams, you can correct me if I'm off the rails here, but I understand that would be the only charge to you in order to buy that time that you need to work out some of these issues that we've been talking about.
Greg, I'll defer to you on this. What do you want to do?
Yeah, through the chair. So I agree with you, Madam Chair, that we're not going to be able to finish off. We haven't even got a proposal from a consultant at this point in time. So I think postponing it indefinitely with the sine die is the appropriate decision.
All right, thank you, Mr. Winters. With that, then, members of the committee, all those in favor of an adjournment sine die? All right, for the record, the decision is unanimous. It is an adjournment sine die. I'm going to wish you gentlemen a lot of luck. There seems to be some issues and some history with regards to development in this area. So I hope you have some great fruitful discussions with the city.
Thank you, Madam Chair.
Thank you.
Thank you.
We have one last one, folks. The last adjournment for 11 Tower Road. I'm looking for Mr. Segreto.
Good evening. Good evening, Madam Chair.
Good evening, Mr. Segreto. You're aware that there is a request for adjournment on your application?
Yes, I am.
Can you just briefly summarize the reason for the decision or the adjournment request?
After speaking with staff, it looks like there may be an opportunity to redesign the building in order to preserve the tree that's on site. So we're going to look at redesigning the house in order to preserve that tree.
All right, thank you. So in this case then, and I'm looking for Ms. Ramirez. Okay, for a minute there, that poor Ms. Cully, if I'm calling on her again. Ms. Ramirez, do you think that the next meeting would be sufficient amount of time for that discussion to happen, some of that redesign, or just before, hold on, Mr. Segreto, you have your hand up. So have you got a date?
Yes, I would like a month.
You would like a month. You'd like to go to March 16th? Okay. Ms. Ramirez, can you confirm that? Do you think that's sufficient time? And that'll work?
Yes, Madam Chair, that would be sufficient time.
All right, perfect. Thank you. Okay, comments, questions from the committee on this before I go to the public? No? All right, is there anyone in the audience who would like to either speak for or against a proposed adjournment of this application to March 16th?
Hello, Madam Chair. It's Nancy Wilson for the Community Association. We agree with the adjournment.
All right, thank you very much, Ms. Wilson. Anyone else? Okay, with that, members of the committee, all those in favor of adjournment to March 16th? All right, for the record, the decision is unanimous. We will see you in a month, Mr. Segreto, although I think we'll see you before then, but on other matters, but we'll see you on this one in a month. Okay, great. We are going to go next to an application for which there is simultaneous translation. This is for 1127 Avignon Court in Orleans. I'm looking for Mr. Bolzuk.
Good evening, Madam Chair.
Good evening, Mr. Bolzuk. Just before we get underway, all right, I do need to read something to you. Do you solemnly swear or affirm that the notice provided to you at the start of the application process and by the committee was posted first at the property to which the application applies, that it was there for the number of days, prescribed number of days before the hearing, and that the sign was at all times visible and legible? Can you either swear or affirm that to be true?
I do swear this to be true, Madam Chair.
All right, thank you, Mr. Bolzuk. With that, we are requesting a presentation this evening. You have a lot of concerns that have come in. I take it that you're familiar with a lot of the comments that have come in on this application from neighbors and from, okay, so we're looking for a presentation and looking for you to address consultation. One of the, what we'd like to hear how you consulted with the neighbors and how you can, and then if you could address the comments that have been submitted.
Absolutely, Madam Chair. I'm happy to give you a presentation. The application before you is for consent to sever a vacant parcel of land from the existing townhouse. The proposed and retained lots both meet the required lot width and lot area under the zoning bylaw. But first, I'll proceed through a site context and history. If you could proceed to the next slide, please. So the subject property is located in the Covent Glen community of Orleans along Jeanne d'Arc Boulevard. The subject property is located on the northeast corner of the intersection of Avignon Court and Jeanne d'Arc Boulevard, as shown on the images on the screen. The area is characterized by a mix of semi-detached townhouse and low-rise multi-unit dwellings. The property currently contains an end unit townhouse on a 15-meter wide lot. The southern portion of the corner lot is currently vacant and is the portion proposed to be severed. Next slide, please. This image shows the property from Avignon Court looking east. You will note the existing townhouse with a front-facing garage and driveway, as well as a municipal lamppost and a tree located in front of the proposed severed lot. Next slide, please. This image shows the subject property as seen from Jeanne d'Arc looking north. The existing townhouse is to remain, including the driveway and the visible rear yard, and the current proposal simply seeks to sever the vacant portion of the property to develop a new townhouse on the severed parcel. Next slide, please. So once again, the purpose of the applications is to sever the existing lot as per the R plan shown on the screen into two separate parcels, one with keeping the existing townhouse and one a new vacant parcel to be created through severance. I would note that both of the proposed, both the severed and retained lots meet the required minimum lot width and lot area under the zoning bylaw, which in the R3VV zone is 6 meters, but under exception 708 is actually 5 meters. As you are aware, the applications were adjourned on January 12th, so there were some changes that were made to the applications as a result of further discussions with staff. So on the next slide, please. As part of the previous application, the proposed lot width was actually 9.04 meters for the severed corner lot, which under the zoning bylaw in the R3VV zone is actually wide enough to accommodate a new single detached development. It was always our intent to proceed with a future townhouse development, and in discussions with staff, there was some concern over the zero lot line. Essentially, if we proceeded with a 9-meter lot width for the severed lot, then that would imply a reduced setback for the existing townhouse. If we were to proceed with the townhouse, then as you know, that 0 meter lot line would be permitted. But if the lot is technically big enough to allow for a single, it's my understanding that there were concerns from staff that if we were to proceed through the zoning bylaw and construct a single, it would create a situation of non-compliance for the existing townhouse. So a bit of a chicken and the egg situation. The proposed solution that we put forth to staff, and we had looked at some other options, and those will come back through a discussion that I'd like to have later about one of the conditions, was to prepare a site plan showing the location of a proposed townhouse, or at least a developable area within the setbacks. One of the other solutions was simply to shift the severance line 9 centimeters to the south, reducing the lot width of the severed lot to 8.95 meters as shown on the screen, which effectively puts the severed lot under the 9 meter threshold, and therefore it would only be eligible for a townhouse, thus providing that assurance to staff that a future townhouse would be constructed on this site. So that is a summary of the main change that came through our discussions with staff, and then those were finalized roughly at the end of January, I believe. Next slide, please. I'm happy to provide an overview, as we mentioned, of the public consultation. As per your advice, Madam Chair, we did consult with the community following the January 12th hearing. Immediately after the hearing, I did receive an email from a neighbor who was seeking more information, and we corresponded by email. I would also note that originally at the time that we posted the signs back in December, we did speak, I personally spoke with the neighbor immediately to the north at 1125, as well as the neighbor across the street at 1128. They came out, asked me what I was doing. I explained that we were posting signs and that the applications were for consent at this time, and that there were no minor variance applications required because the severed property and the retained property both met the requirements under the zoning bylaw. They asked me, well, what are you going to build? What's it going to look like? And I advised them that at this time, we're not proposing new construction. This is simply the severance of the lands. The owner wanted to take a multi-step approach with respect to the development of the site. And the first step in that would be the severance of the lands, followed by drawing up a site plan and architectural drawings for the development of a townhouse that meets the zoning bylaw. So that's sort of the discussions we had in December. It was my understanding that, some of the neighbors were a little unhappy with what we were doing, but at the end of the day, there's a process for discussion. And I did advise them that, I work at FOTEN. There's a phone number on the sign for the Committee of Adjustment. And as the applicant, you can contact them to get my contact information. And I'd be happy to walk you through the application or answer any questions. So at the January 12th hearing, as you know, there was a petition circulated by the neighbors, and I've identified their addresses on the screen because following up on February 1st, after we had these discussions and revised the R plan, I actually went and dropped off letters to all of the neighbors who had signed the petition that was circulated on the 12th. And I also added 2 other properties that are shown with the yellow circles because they were in proximity to the site. And I thought if we're going to have a discussion, they may want to be involved. I can note to you, Madam Chair, that I have not received any follow-up emails from anyone for whom I deposited the letters on February 1st. So that is my summary of the public consultation. Like I said, I did speak with one neighbor by email who I don't believe was part of the petition. They were simply looking to understand because I can recognize that it might be a confusing application to those of us not in the industry. But essentially, we did make an effort to reach out to the neighbors who signed the petition, and I have not received a response until, of course, the technical circulation package that we received in advance of this hearing, noting some of those concerns raised by the neighbors, but they did not contact me directly. Next slide, please. Briefly to touch on the criteria for consent, we note that, in our opinion, a plan of subdivision is not required, as both properties will have separate access to municipal infrastructure and frontage on municipal roads. That's partially assured through the conditions of approval. I will now walk through the criteria under section 5124 of the Act. Next slide, please. The proposed lot is to be developed with new housing that is characteristic of the existing subdivision, which includes semi-detached and townhouse dwellings. Further, it promotes efficient infill development on municipal services and will contribute to the mix and range of housing options in the area. Next slide, please. The proposed development is designated general urban area under the current official plan and the minor corridor under the new official plan. Both designations permit townhouses and other medium density type residential uses, and the policies of both plans encourage and promote infill development on full municipal services. Next slide, please. The surrounding area is characterized, as I mentioned, by townhouses and other similar dwelling typologies, including planned unit developments just across the street. The retained and severed lots both meet the required lot area and width under the zoning bylaw. And finally, the proposal is similar in condition to the semi-detached development across the street at 1130 Avignon, as you can see on this slide. It's not introducing a condition that does not already exist with respect to the proximity to Jeanne d'Arc. Next slide, please. As noted on the R plan, both lots are designed to be rectangular and regular in shape. And for the severed lot, it is capable of accommodating a new future townhouse to be designed should this receive approval. And both lots meet the minimum requirements under the zoning bylaw. Next slide, please. Finally, there are no proposed restrictions on adjacent lands, including easements. Any issues related to the shared wall will be managed through an agreement between property owners, although at this time it is the owner's intent to keep both properties for the time being. And next slide, please. To conclude the presentation, the proposed severances meet the criteria for lot division under the Planning Act. The applications present an opportunity for quality infill development that matches the context of the community. And finally, the proposal is appropriate and desirable for the lands, making efficient use of the vacant portion of an existing corner lot. To come back and speak to specifically the concerns that have been raised by the community. One moment, please. It's my understanding that a lot of the concerns have to do with traffic and sight lines along that corner lot condition, specifically with the proposed new driveway along Avignon. I would note that we haven't designed the building at this time. We haven't decided on the final location of the driveway. We did originally investigate this last summer with staff when we were initially approached by the owner. And we did reach out to a different planner. Obviously, the staff changed. But the comments that we received from the transportation department is that while there would be a preference to locate, there's a general preference to locate your driveway along a local street rather than a major collector such as Jeanne d'Arc, that there were some site-specific challenges that might pose some issues with respect to installing a new driveway. One is the proximity to the intersection at Jeanne d'Arc on that side. And if actually we go back a few slides to the aerial, it might be better to illustrate. I'm specifically thinking, yeah, actually that's perfect. Thank you so much. You can see that the driveway across the street has a similar condition and is located quite close to the stacking for a right-hand turn or a left-hand turn along Avignon. So while I believe we do meet the minimums for a driveway on that side with respect to proximity to the intersection, I can understand the concerns from the community that it's rather tight. In our case, we had actually asked staff to confirm with the transportation department if a new driveway installed into the rear yard of the proposed lot would be acceptable. And the answer that we had received at the time, and I believe this was June, July last year, was that, again, generally new driveways should be located on locals versus collectors. But in this case, because there are other driveways located along this portion of Jeanne d'Arc, just east of the pathway to the park and school, we're not introducing a new condition. And also there are some challenges on Avignon specifically, including the proximity to the intersection, as well as a lamppost and a tree that would have to be removed for the tree and for the lamppost actually relocated. And it's my understanding from those comments from at the time, Mr. Hodgins, that the city was concerned about where that lamppost could actually go. And so we're not sure if a driveway on Avignon is the best option. And in that sense, we would agree with the community. I would note to the community as well that one of the conditions is a corner site triangle, a 5x5 corner site triangle that will have to be registered. And that does provide for sightline protections for oncoming traffic. I know a lot of the concerns raised with respect to that had to do with a fence that the previous property owner had put up in order to create additional parking in his side yard, is the story I've been told. And that caused some site issues and there were some concerns. So I guess I would say in this case that through the corner site triangle and through our attempts to locate the driveway on the Jeanne d'Arc side, obviously our client is also interested in not making the intersection any worse from a traffic perspective. There's an inherent interest in making this safe for the future tenants or owners of this building and all existing members of the community. So I know traffic was the main concern, especially with respect to the driveway location. There were also some concerns raised with respect to urban design and the future design of the building. A few neighbors had noted a pattern of townhouse garage, townhouse garage, townhouse garage as it goes down. In this case, it would be difficult to maintain that pattern because of the fact that this garage is actually located in the front yard. So this townhouse would be adjacent to the existing townhouse. And if there was to be a garage constructed, it would likely be at the rear on Jeanne d'Arc, or at least that's what we would be hoping to achieve. I recognize that staff through condition 9 are looking to impose through a site plan that the driveway would have to be located on Avignon and that the new dwelling would have to face Jeanne d'Arc rather than Avignon itself. So I can get into that now if you want to know my opinion on that, but I believe that sort of summarizes the public comments. And I do thank the public for providing that input and I've gone through them. I'm not sure I have more of a response, Madam Chair. I apologize. I think I went over my 5 minutes.
Well, that's fine, Mr. Budzik, because when we get into some of these more contentious issues, it is important to get the information that we need, and we hope that this is helpful to everyone who is who's listening in and who wants to participate in these in this particular item. Okay, so with that, I'm going to open it up directly to our committee members. Questions, Ms. Willis, go ahead, please.
Yes, Mr. Baldock, I'm just wondering, am I correct in my understanding that as you mentioned, that the other townhouses in this row are connected through the garage, they're connected by the garages, thereby allowing access from the front yard to the rear yard, but the end unit is different from the others. So I'm wondering whether by constructing another townhouse and severing the property, does that not cut off the access for the resident of part 1 to get from his front yard to his rear yard? And isn't an access easement therefore required as part of this application?
My understanding through you, Madam Chair, is that they would have access through the building. Perhaps I'm not understanding the question, but they would have access to the rear yard through the townhouse, through the existing townhouse.
But in the case of on-street townhouses where there's not a garage access to the rear yard, for you to get your lawnmower from your front yard to your rear yard, you require a 1.5 meter access easement across your neighbor's property to get to your rear yard. That would be facilitated through the garages where they can go from their front yard through the garage, and presumably there's a rear door from the garage to the backyard. But in building this additional, in severing this additional lot, there's no means for that person to get equipment, lawnmowers, that sort of stuff from his front yard to his backyard.
My understanding is they would have to go through the house. I have seen other townhouse developments in Ottawa and elsewhere where that is a condition for interior townhouses, whereas end units would benefit from being able to go around through the exterior side yard. So it would be a different situation in this case, but I don't believe it's an overly onerous burden on the property owner.
My understanding is that access easements are a requirement of site plan approval where you can't get directly from the front yard to the backyard. That certainly has been the case in on-street townhouse developments where there's actually severances of the properties on the public street. Maybe staff can comment on that.
Looking for Ms. Cully on that, please.
Through you, Madam Chair, that is typical, yes.
Is it a requirement?
It's typically provided, is my understanding. I don't know if it's necessarily a requirement. That's not something I have the direct answer to.
All right, so I guess what I'm wondering is, and I think Ms. Willis, you raised a really good point here, because typically we would want this as part of a consent to allow for the creation of an easement on this parcel. we can't make it a condition because there's nothing to say that in fact the development will occur within the 1 year timeframe that's sort of required to meet all of the conditions. And they won't know because if they decide not to move forward with the development, to Mr. Bolduc's point, they don't have a design, they don't know exactly where the driveway is at this point. They don't, so being able to identify exactly where that easement should be, if you make it a condition, then you're essentially saying, well, you really have to get on with your development within a year.
Well,
So I'm not sure how to deal with it.
I just think, or alternatively, what happens when he goes for a building permit? I'm assuming that he's not making a change to the old site plan that would have been in place, I think, at the time that this was originally approved, but he'd have to come back before the committee to get an easement as part of the, like a consent process, be back to us.
At that time, that's right. I agree with you there. I was just trying to figure out, we can't deal with it tonight, is essentially what I'm saying, so.
Yeah.
All right, good point. Anything else, Ms. Willis?
No.
All right, thank you. Mr. White?
Thank you, Madam Chair. I have a couple of issues I'd like to see addressed. I want to question the staff. In my experience, these types of development, which include street townhouse projects, and it's a mixed subdivision, includes, I think, semi-detached. I'm not sure about singles, but certainly semi-detached and street towns. They're traditionally as a site plan or subdivision agreement, which includes provisions relating to the siting of the townhouse units in particular. So in other words, normally there's a registered site plan agreement, registered on title, binding on all of the owners of that, in that subdivision. That requires that any changes that be done to any revisions such as is being proposed here, that are being done to the site plan agreement or site plan subdivision agreement, require an amendment to that document. Is that not the case in this situation? If so, if it is the case, then I think there's more approvals that are required beyond just simply a severance from the existing townhouse, single townhouse.
Through you, Madam Chair, the subdivision agreement that would have been approved at that time was not reviewed. It doesn't appear to be in my notes. So that would be something that I would need to review in order to answer that question.
Thank you, Madam Chair. I think that's a fairly...
Sorry, sorry, Mr. White. I could see that there was others sort of speaking up. So go ahead, Mr. White.
Yeah, I think that's a significant question that we haven't got an answer to here. Because in that case, if that's the case, there are other parties that are there parties to that agreement that need to have some input into the proposal.
So maybe I was going to ask Mr. Bolduc to know whether or not he looked at the subdivision agreement and whether he can answer the question. Mr. Bolduc?
Madam Chair, I can't answer that question, no.
All right, okay.
Secondly, Madam Chair, being that we're talking, and I think one of the residents' correspondence that we received addressed this point, and there were some other good points I think they addressed, and I'll leave it to them to go further on their points. But one of the issues that was identified was how the existing townhouse unit is going to be integrated with the addition of a townhouse unit based on the location of the services to that existing unit. I think it's correctly pointed out that there appears to be, gas connections, connections for the furnace, water, likely water connections, etc., to that common, what will be a common wall. There's also vents for bathrooms and kitchens, etc., that may be there that have to be dealt with. Has that been taken into account in terms of the concept of the townhouse addition of the townhouse unit here? So, and then another question: staff's position in terms of the access for vehicular driveways appears to be very favorable to the installation of the driveway on Jean d'Arc as opposed to Avignon because of the safety issues that have been brought. Concerns that have also been echoed by the neighbors. So that's a question I think that needs to be addressed. But fundamentally, I think that question about the site plan agreement, subdivision agreement, needs to be answered before we can really deal with the question.
All right, Mr. Volcik, did you want to respond to that?
Yeah, I would like to respond to the question about integrating with the existing townhouse. Following the previous hearing, we did look into that. We did consult with the project architect just to get some preliminary opinions to see if it would be difficult to essentially add a townhouse per our plan. It's my understanding that there were no initial concerns. The two exterior windows that you see facing Jean d'Arc are both related to a stairwell that actually accesses the upper floor, and so that they're not bedroom windows or anything else that would violate building code with respect to those changes. So we don't have any of those initial concerns, and of course for servicing and utilities, we would consult with the civil engineer and do what's required in order to service those properties accordingly.
Thank you, Mr. Bolzik. Any other questions, Mr. White? Oh, you're on mute.
Not at the moment, Madam Chair. Thank you.
All right, thank you. Ms. Wallace, you had your hand up.
No, I was just, I think it was just addressed that it's quite possible in those days back in Gloucester that they would have done a subdivision plan for the overall street, identified blocks, and they probably did a site plan application and then lifted part lot control in order to create the separate lots. So there's probably a multitude of agreements that are impacted by this addition. That was all.
Thank you very much for that. Anything from Mr. Hindle, Ms. Markovich? Any questions? No? Mr. Hindle.
Yeah, I just had a question for the applicant. I guess in this case, the zoning, it would be considered as a corner lot, I imagine, with larger side yard setbacks than standard?
Correct. The corner side yard, I believe, is required 3-meter side yard.
Right, so can I ask whoever is not got their mic on mute to do so, please? You're disturbing the proceedings. Okay, sorry, Mr. Bodzik, go ahead.
Sorry, I would just repeat that I believe the corner side yard is a 3-meter requirement, and we have mocked up a concept site plan just to understand the setbacks and understand the volume. When I say site plan, it's very crude. I drew it myself and I don't have the talents, but just enough to understand the setbacks for our conversations with the architect, and they confirmed that there doesn't appear to be an issue. It's a 9-meter wide lot that we're proposing, well, 8.95. So.
Right. Okay, so you're confident that in this case that the resulting lot would be indeed buildable, and there obviously options for parking and all those kind of access, but otherwise is a buildable and easily workable kind of lot.
That's correct. Initially, when we took this on, I don't mean to keep going, but we looked at what is the path of least resistance, essentially, when determining the application. We recognized that if we were to go with the 5-meter lot width and we were to push the severance line right up against the wall, it would create a non-compliance condition with respect to the driveway, occupying more than 50% of the frontage of the house. So by pushing it to 6 and then through a site plan actually removing a portion of the asphalt, which conveniently works into the drainage plan where the existing downspout is, we've kind of workshopped this with an architect and with the client to say, yeah, we can make some real positive changes to the existing building while accommodating the new one and having enough room for a regular rectangular townhouse on this site. Again, assuming our preference is still to locate the parking off of Jean d'Arc and have those spots go directly into the rear yard.
Okay. And can you tell me just a little bit as to why the preference is in this case that it be a townhouse and not a single detached?
It's more of an administrative consideration, or sorry, a zoning bylaw consideration. If we did have it at the 9 meters, the only way to create a 9-meter lot is essentially to have a 0 lot line from the existing townhouse or a reduced lot line, whereas 1.2 would otherwise be required. So as soon as you include that 1.2 for the townhouse to create a new single, we'd have to seek a variance to the lot width in order to create a new single. So we explored that option and we said that's going to be a very narrow lot for a new single and probably not something that the committee would approve. So instead, by committing to a townhouse on a lot that is significantly wider than required for a townhouse in this area, at least we know that we're meeting the bylaw. We're not needing any variances. We can just throw it through the consent process, which we had initially anticipated to be a little bit less contentious. And so we basically tried to say, let's do this without variances. Let's go through consent, keep it clean, meet the bylaw. And now we're running into some adjacent issues.
Okay. No, that's helpful. Thank you.
Mr. White, is your hand up anew or is that from before?
No, the question of the single versus I'm glad Mr. Hindle brought this up. The question of single versus the townhouse. Question to staff, is there a reason? I'm not following the zoning bylaw issue here. Is there not if a single detached is oriented to John Dark with the access and possibly the main entrance of the building, although I don't think that's absolutely necessary either. I think you can do a split access with vehicular off of John Dark and the main entrance off of Avignon. I did send our members of the committee some examples that I've seen in other situations. Is there a bylaw constraint to having a single oriented to John Dark in terms of the access and or the main entrance? Can that not be accommodated and bylaw requirements be met, citing essentially your usable rear yard area to the adjacent to the park entrance on the, I'll call it the right side of the lot, if that's the case. That's how it's developed. Is there a constraint? Does the line meter lot depth create a problem that way?
Through you, Madam Chair, if I understand correctly, you're saying that the front lot line would be on Avignon and the rear lot line would be abutting that park. Is that correct, Member White?
I'm saying well, I would call it the front lot line with the entrance to the building, the access to the building, or the access to the driveway fronting on John Dark.
So the bylaw defines front lot line as the shortest lot line when you're looking at a corner lot. So in this case, the lot line on Avignon is the front lot line as defined in the bylaw.
So does this lot would this lot be constrained if the entrance to the building, the face of the building is fronting on a single detached is fronting on to John Dark?
If the frontage is facing John Dark, that doesn't necessitate it being the front lot line. Is that the question you're asking?
Yeah, I mean, can I develop a single on this lot?
No.
Onto John Dark?
Through you, Madam Chair, no, you could not, based on the definitions in the bylaw.
Okay, thank you.
All right, thank you for that.
All right, can I develop a townhouse that fronts that way?
Through Madam Chair, yes, you could develop a townhouse because the lot is compliant with the townhouse requirements for the R3 PB zone.
Okay, thanks.
Any further questions, Mr. White? Okay, all right. Okay, so if that's it for the questions from the committee, back to the agent. What I'd like to do before we go to the public portion here, Mr. Budzik, and I was a little remiss, I should have taken care of some of these housekeeping matters with you at the beginning. So just in terms of changes to the notice, apparently the legal description, we have to add some wording, which would be to add Part 24 unregistered plan for R3100. Is that correct?
That's my understanding per the PRED report. Yes, Madam Chair.
All right, and we're also changing the zoning designation to R3V and then a V exception 708 in brackets.
That's correct, Madam Chair. It can get confusing in the bylaw sometimes when the two V's are next to one another. It looks like a W. And actually, if you go look at exception 708, you'll note that it looks like R3W applies and that 708 wouldn't apply to the R3VV zone. So I apologize to Ms. Cully if I didn't make that clear through our application. But yes, it is VV, not W.
All right, thank you. And in terms of the frontages, there are some changes here to lot area and frontages for both parcels. I'm going to read them out, just need you to confirm for the record. So frontage for 1127 Avignon, then is not 6.1, but rather 6.19. And the area is 186.4 rather than 183.8. Is that correct?
That's
Okay.
correct, Madam Chair.
And for the new lot being the 1129, we would be looking at new frontage of 8.95 rather than 9.04 and 272.8 square meters rather than 275.5.
That's correct.
All right, perfect. Okay. With that, that's the housekeeping items. I don't think I have anything else. I am going to open it up to the public portion now of the hearing on this item. And I do have quite a long list of people who have registered to speak. I'd just like to make one comment before I open it up to the first speaker. If you've heard somebody, a neighbor, say something that covers your concern, then you don't need to repeat it. And I can assure you, I take good notes on these things. I write down what we're going to need to explore once everybody's concerns are down. So we're in order to try and get to everybody on the agenda tonight in a timely fashion, I'm going to ask you to not repeat what you've already heard from somebody else say, a neighbor say. So with that, then I'm if everybody could just hold to that, and there is a 5-minute maximum for every speaker. So with that, I will take it to the first person on the list, David and Linda Wright. Do we have David and Linda Wright? I'm looking to the coordinators to tell me whether or not you see them in the audience. All right, I see Mr. Wright.
Sorry about
Good
that
evening.
delay there. No, we do not intend to speak. We're just here. We wish to be observers only tonight. We have nothing further to add. Thank you, Madam Speaker.
All right, thank you, Mr. Wright. Next one on the docket is Mr. Paul Summers. And Mr. Summers, I see that your hand is up. I think that that's you.
Let's see, do we have camera? Start my video, I guess. Do you get picture? Or
Oh, we do not see you, Mr. Summers. We do not see you.
okay. Okay, so I guess I will just speak then. Actually, first time on this type of meeting. So yes, I'm sorry. I'm Paul Summers, 1125, the next door neighbor of 1127. As Mr. Baldock showed on some of the pictures there, if you look at the existing driveway of 1127 plus the cement add-on that is like the width of the sidewalk leading to the house, that leaves very little frontage for landscaping. And well, given winter, where would the snow of 1127 end up if not in the street, which is one of the concerns for something that is right at the entrance of a court configuration street. The other thing is the maintenance of the new 1127 backyard, which will need, believe me, some landscaping. And also, I have concerns about polluants because the land was used as a parking lot for hauled vehicles, for one thing. And there has been seepage of petroleum fluids in the ground. And I would suggest that contamination be addressed before the new 1127 loses Front Street access, unless there is some provision that I'm not aware of, that access could be made to do landscaping via the park. Because it seemed the only other access was through the property. So moving gravel, sod, and everything through a property, I don't know. I have concerns for my to-be new neighbor outside upkeep. That's about all I had.
Anything else, Mr. Summers?
Nope, that would be my comment, like how will maintenance be done in the backyard, and where does the snow go on the front of this puny frontage of the new 1127 Avignon?
All right, thank you for your comments. We'll come back to some of the issues. I just want to get all the issues on the table right now. So I'm going to go to the next speaker. Based on that, then, does anyone on the committee have a question for Mr. Summers? No? All right, we'll go to the next speakers then. Mr. Yvan et Nicole Cuerier. Bonsoir, vous êtes... Non,
bonsoir.
On va
Oui,
vous
bonsoir.
entendre maintenant.
Merci,
voulez-vous parler en
madame.
français? Voulez-vous parler en français, M. Cuerier, ou en anglais?
Si possible, en français.
C'est parfait, oui. Si vous voulez parler en français, aucun problème. Ça fait que... Allez-y.
Oui, je viens d'entendre M. Sommer qui avait plusieurs des items que j'avais à mon agenda. Et c'est très valide aussi. Maintenant, je suis concerné surtout, comme il disait M. Sommer, c'est 1127 Avignon. Un jour va appartenir à quelqu'un d'autre que le propriétaire actuel. Alors, cette maison, le 1127, va devenir la maison qui n'est pas standard dans le développement, dans le sens qu'elle n'a aucun accès à la cour arrière. C'est un issue aussi. L'autre, c'est que la cour arrière fait face à l'entrée du parc et aussi à la cour arrière de l'école primaire d'Orling Woods. Donc, les enfants, c'est leur cours d'école à l'arrière. Alors, on est concerné que peut-être qu'il y aurait des véhicules lourds qui pourraient être utilisés pour faire des modifications à la cour arrière. Deuxième chose, aussi la neige, il y a un gros problème parce que je suis directement en avant. Alors, si on envoie la neige dans la rue, c'est moi qui vais la pelleter quand la chose va passer. L'autre question aussi, c'est l'accès très limité, même, je dirais pas limité, mais presque impossible de sortir d'une entrée sur la rue Avignon pour un auto et de faire un arrêt légal à l'arrêt. La moitié d'auto est dans la partie entrante des automobiles qui va rentrer sur Avignon. La cour Avignon est c'est la même entrée et la même sortie. Alors, il n'y a pas d'autre sortie ni d'entrée à cour Avignon, excepté celle-là. Alors, c'est très, très près. Et si vous avez vu les photos, j'ai pris des photos pour démontrer qu'en sortant du potentiellement 1130 Avignon, on obturait la rue pour faire l'arrêt au coin. L'autre issue que j'avais aussi, c'était le fait que le coin d'Avignon et Jeanne d'Arc a été le site d'au moins 4 à 5 accidents là, impliquant des véhicules qui sont ramassés sur les bâtisses existantes sur le coin d'Avignon. Et aussi un accident mortel qui est arrivé au coin d'Avignon aussi et Jeanne d'Arc. Alors, c'est un point très, très achalandé. Et aussi, c'est un arrêt pour au moins matin et soir de 10 autobus scolaires qui ramassent les enfants directement sur le coin d'Avignon. Donc, rajouter un véhicule qui potentiellement obtuerait la rue, ça crée un problème supplémentaire aussi. Là, je regarde mes petites notes, mes petites photos. Est-ce que vous avez eu les photos?
Oui, on les a vus vos
OK.
photos. Merci.
Alors, je me dis une photo vaut 1000 mots. Alors, c'est le point que j'appelle. Aussi, on a parlé que quand ils ont posé des pancartes sur le coin d'Avignon, oui, on s'est demandé qu'est-ce qui arrivait. On nous a dit que c'était pour demander une dérogation de terrain et point à la ligne. On a reçu une lettre par la poste il y a une couple de semaines expliquant la même affaire qui était marquée sur le coin d'avis, c'était pour la partition. Il y avait un plan qui, j'étais sceptique puisque le plan qu'ils nous ont montré, le plan d'arpentage, était ni signé et ni daté. Donc, je ne sais pas sur quel document que la ville s'est basée.
C'est souvent très commun que c'est en fait des plans qui sont en ébauche parce que ça prend l'approbation pour venir à bout de le finaliser. Essentiellement, c'est comme ça que ça marche. C'est toujours en ébauche quand ils regardent, mais c'est très proche là, de l'état final là, du plan, de toute façon. OK. Fait que je pense que ce que j'ai bien compris, il y a beaucoup de trafic vers l'intersection, beaucoup de potentiel pour d'accidents. Qui est vraiment historique de toute façon, de ce que vous avez expliqué. Il y en a eu déjà beaucoup auparavant. Vous avez peut-être des inquiétudes aussi au niveau de la neige dans la rue. Puis après ça, je pense que c'est la cour arrière, peut-être l'impact sur l'école, puis d'autres choses. Mais ça, c'est plus ou moins quelque chose qu'on on s'occupe de ça plus ou moins pendant la construction, ce qui veut dire que c'est pas vraiment pour le comité. Le comité se penche pas trop sur la question de comment faire une fois que l'approbation est mise en place. Ça, c'est construction, puis ça va avec d'autres sections de la ville. Fait qu'on peut pas trop répondre à ça. Mais c'est correct. Est-ce qu'il y aurait d'autres choses?
Oui, puis d'autres choses, c'est aussi que le 1127 Avignon va devenir une maison sous standard pour le quartier Avignon.
Pourquoi vous pensez que ce serait sous standard?
Parce que, justement, comme on parlait, si on veut amener un barbecue à l'arrière, il va passer par la maison, par le salon, par la salle à dîner, et puis ça remonte en arrière. On amène une bonbonne, ça va passer par le même chemin. Si on veut amener la tondeuse, c'est la même chose. Et puis, comme on a démontré à l'arrière de la maison, il n'y a pratiquement pas de place pour y placer des services d'eau, des services de compteur à gaz, des services de ventilation pour les fournaises, pour les chauffe-eau et des prises d'air pour la fournaise. Alors, si on met un mur adjacent au 1127 Avignon, il n'y a aucune place pour le mettre. On a beau dire qu'on va le faire dans les plans futurs, mais on n'a aucune idée de ce qui va se passer. Maintenant, la question qu'on est très hésitant, c'est que pendant, 5 ans, on a eu beaucoup de difficultés avec le propriétaire du 1127 Avignon. La ville était là tous les jours, à toutes les semaines. Ils n'ont jamais été capables de faire observer le règlement. Et si le propriétaire ne suit pas le règlement, la ville a de la difficulté à les faire respecter. Alors, juste point de vue-là, si on regarde dans le futur, on va être pris encore avec un même problème où ce que la ville va devoir se débattre et attendre un autre 5 ans, 6 ans avant de résoudre. Alors, c'est pour ça que je sais que ça fait pas partie d'aujourd'hui. Mais c'est de là où on vient maintenant. Là.
OK, merci. Mais c'est comprenable là, si vous avez déjà vécu avec une situation que vous avez trouvée difficile puis qu'il y a eu des problèmes. Oui, on peut comprendre pourquoi que vous voyez peut-être le potentiel dans le futur, mais pour nous, c'est vraiment pas une question pour notre décision. C'est tout un autre département de la ville qui s'occupe de ces affaires-là. C'est vraiment pas le comité de dérogation. Fait que, OK, fait que c'est beau. Autre chose?
Non, c'est beau. Merci beaucoup.
OK, merci, M. Curier.
Oui,
Cuirier.
merci.
Okay.
Cuirier, c'est bien ça.
Cuirier, c'est ça. Merci. Okay. With that, I'm going to go to the next speaker then, Ms. Pam Carter.
Madam Chair, she's not online.
Not online. Okay, so we don't have Ms. Carter. Ms. Nadia Roy.
She does not appear to be online as well, Madam Chair.
How about Mr. Andy Leo?
Madam Chair, I don't believe the other two are not online as well.
So that would be Ms. Ghislaine McKenzie is also not available?
Correct.
All right. Okay, so not available. All right. Okay. Before we go to asking getting resolved some of the issues that have been raised, Mr. Budzik, I see that you have your hand up. What did you want to add or respond to something?
Yes, I would just, if possible, Madam Chair, to respond to some of Mr. Cuillerier's concerns, and I'm happy to address those in French as well. Monsieur Cuillier, je peux vous dire que c'est pas le même propriétaire avec qui vous avez eu des problèmes dans ces dernières années. Le propriétaire à qui je travaille, ils ont acheté le propriété, je pense, ça fait un an et demi. Alors, c'est pas le même propriétaire. Le promoteur de ce développement cherche à améliorer le landscaping, à développer le site, puis à créer vraiment un beau développement. C'est pas la même situation, c'est pas les mêmes personnes avec qui vous avez eu des beaux problèmes ces dernières années. On comprend que c'est frustrant d'avoir ces problèmes, surtout le stationnement de la side yard, puis les problèmes avec bylaw. Mais encore, c'est juste pour clarifier que ce n'est pas le même propriétaire. Ils l'ont acheté de ce dernier.
Okay, merci, Mr. Budzik. Okay, so just wanted to come back to one thing that was raised by Mr. Summers that I think is worthy of exploring. It has to do with the use of the property. Monsieur Pierre, okay, merci. And I guess this is, I'll be looking to Ms. Cully to help us out here. So I'm hearing there's been a bit of a history with the property, and Mr. Budzik, you could help too. A bit of a history of a property where there's been parking of vehicles on the grounds. So I just want to see whether or not there is an issue with potential contamination and whether or not we need to be doing anything about that. Ms. Cully.
Through you, Madam Chair, that issue is not raised, so there wasn't anything that the city has noted to be of concern in that case with regards to it being contaminated. There hasn't been anything raised to my knowledge.
All right. Mr. Budzik, any comment on that?
Yeah, the history that I've received from the new owner of the property is that, as you can tell well, actually I have it on my screen here, I apologize, you don't have it, but from the street view, you can see that there was some gravel laid down. My understanding is that the previous owner had a lot of friends with motorcycles and that they had put gravel down over some of the landscaping in order to provide additional parking for them. And that may have been the source of some of the issues. Our intent is to redevelop that land. I'm not aware of a requirement through this process for an environmental site assessment. Although if it were to be required a building permit, it's not a site plan. So I don't know when that would come in. Yeah. And there's also, there's no change in use. It's residential, so there's no record of site condition. So I can understand that concern, but it hasn't been identified at this point as an issue requiring further study.
All right, thank you. I am a little concerned about it though, in the sense that if there has been any leachate into the property, then because of that use, but I don't know any of the history of it. And I suppose part of what I would have wondered is if bylaw had been called to the property that many times, is there anybody who's got records? Does the city have any kind of background that they could assess to see whether or not there would be a potential? But anyway, if it hasn't been raised, it hasn't been raised. It may be because it was so temporary at this point that it wasn't a commercial use, or it wasn't, so there is from time to time people parking their vehicles on their property, and you can't call that a contaminated site every time that happens, because you think maybe some gas has somehow leaked onto the property. But so I'm just want to make sure that we don't, because Mr. Summers raised it, I wanted to just see what we knew about that issue. So and what I can tell, it's probably not an issue at the end of the day. Okay. So moving on then on some of the issues, do any of the members of the panel have any questions surrounding some of the issues that you heard from our speakers tonight?
Madam Chair.
Yes, Mr. White, go ahead, please.
Madam Chair, I think the issue that's been brought up by the residents is quite valid with respect to the accessibility to the rear yard of the existing dwelling unit. Normally under under the site plan approval, subdivision approval process for street townhouses like this, that's a major issue that's dealt with through the subdivision and site plan control process, providing and securing an access to allow the resident of the interior unit, like this will now be, to service his backyard. The concept of bringing lawnmowers through living rooms just is not a practical or sensible thing to consider. In my view, I think this is a matter that, being that we are functioning as the subdivision approval agency, or being asked to, that it's something that we need to address in our decision-making process on this application. Also, I did bring up the point about the fact that there is likely a site plan agreement that's registered on title here, which involves other parties that are subject to that agreement in terms of an approval process. So I would suggest to the residents that they may want to look at their title to check for the existence of a site plan agreement and what their legal rights might be under that agreement with respect to any further future development of these lands. So anyways, to sum up, in my view, that access to the rear yard situation really should be something we should deal with if we're going to make a decision on this one.
Well, so I understand what you're saying, and I think that's a valid concern too. But we don't have an application before us for consent to allow for the creation of an easement. We don't have a draft plan to show us where that easement might be. And we can't deal with it by condition, because you wouldn't possibly be able to expect them to clear the condition, and therefore their approval would lapse. So the only other option you have is either you adjourn this application right now, you require them to go back and apply for a consent to get the easement in order to show where that would be and allow that functionality on the site, which I agree is very standard. So I found it a little strange that we would ever consider taking lawnmowers or barbecues through somebody's house. But so what we're left with, though, is you either adjourn or we approve the severance as it is and allow, and this is where I'd want confirmation from staff, that in fact, it would be picked up at the time of building permit, and a requirement to come back to the committee for that consent for easement would be triggered. So Ms. Willis, go ahead.
I'm just wondering, Madam Chair, because I do think an easement is required. And I think that, having done a gazillion of them over the years, normally what it would be simply, I mean, there's two opportunities in this case. It could be 1.5 meters that goes parallel to if the unit was to be fronting onto Avignon, it would come along the side lot line and wrap around the back and just stop at the edge of the property. It would just be 1.5 meters. Or it could be just straight along the rear property line, and then the 1125 goes out the front door, around the corner, down the sidewalk, and up the easement. And if they fence between the two, there's got to be a gate to allow them access through. So I don't know why we couldn't make it a condition. It's a matter of a reference plan. They're going to have to do it anyway. They would simply have to put the access easement on to the satisfaction of the same people who'd be approving it anyway.
I agree.
All right, so the next discussion with the committee then is whether or not we're comfortable in dealing with that as a condition. So typically, the proper procedure would be to adjourn tonight, get that consent application, have the 4-hour plan squarely before us, have a chance to look at exactly what it is that they're proposing, and deal with the two together. My preference is to go that route. I'm not altogether comfortable conditioning the creation of things like easements over property without knowing exactly what it is that I'm looking at. So, thoughts then from Ms. Markovich? Condition, adjournment.
Yeah, I mean, thank you, Madam Chair. I mean, I think the option of a condition could work for me. I'm just noticing, although Ms. Cully has her hand up, and I wanted to just signal at one point, I saw another member of the public's hand up, and I just wanted to make sure that individual had an opportunity to speak before we actually came to a decision.
All right, thank you, Ms. Markovich. So I will let Ms. Cully speak. I did see Mr. Summers' hand up, but as you know, no member of the panel came back to ask Mr. Summers a question. So typically the way it works is we don't go back and have a discourse with the members of the public. We get their concerns, we explore them with staff, and then unless there's a question to come back to the speaker, we don't do that typically. And that is why, Mr. Summers, I didn't acknowledge your hand. Just so you know, I didn't notice it, wasn't quite the process. That's why. And I tried to explain that in my opening remarks. I do try to make that pretty clear. So that's why I didn't come back to you. So Ms. Cully, though, if I didn't see your hand, so if you have something you can add to clarify, that would be great.
Through you, Madam Chair, I just wanted to clarify that if an easement is put in as a requirement through a condition, the applicant would still need to return to committee because the city would not be able to approve any easement, just to make that clear.
All right. So, and there you have it. So it's a decision of the committee, and I totally understand that. Thank you, Ms. Cully, for reminding us. They don't have the authority to create an easement. The easement actually has to be approved. We have to approve something that we're looking at with regards to, I think it's a 4R plan. We can't delegate that authority that's been delegated to us to create under consent the easements to staff. Or at least I don't think so. And I'll tell you, if we can, then I'd like a legal opinion on it. Okay, so I think we're looking at an adjournment, frankly, is I think what we're looking at this point. Mr. Bunsick, you've heard the direction this conversation is going in. So over to you for a minute.
Yeah, and thank you everybody for your comments with respect to the easement. If it's what would make the committee comfortable proceeding with the application, then I can certainly discuss with my client and look at our options for, I believe it would be a secondary consent application, given the existing applications in the door. I think one avenue we haven't explored, and I'd be curious to get staff's input and your comments on this, is I know in other municipalities I've worked in, it's not impossible to get an easement over a portion of the municipal property to the rear, adjacent to the public pathway, in order to just put a fence or essentially put a gate on the back and allow anything to come through the public property directly through a gate. I don't think that's a bad option in my personal opinion, but I don't know if the city would be agreeable to this.
Well, and I think that's a discussion with far more than the people that are involved in discussions here tonight, Mr. Budzik. So I think you'd have to go back and consult with the right, and I think planning staff would have to go back to their colleagues like at legal and anywhere else. I don't even know if it would involve some of the real estate people too, so.
And sorry, Madam Chair, if I may, I believe a follow-up question to that would, if that were to be possible, could that then be included as a condition of approval to say that you have, an agreement with the municipality for partial access off an existing MUP?
Well, so I can't answer that question because we don't have any kind of agreement from the city on anything like that right now. Understood. If that's the direction that comes back to us under an application for an easement, then so be it. We'll look at that, right? It'll be part of the discussions that you have with the city on that. Okay, Ms. Williams, back to you for a moment. If we need a new application and Mr. Budzik, you can pipe in too, because you're going to need to get a draft 4R plan on something like this. I think March 16th is too tight to get this done. So
we would need everything by Friday.
So April 2nd, how's that meeting look?
April 6th. Yes.
No. Is it April 6th or April 6th? Oh, it is April 6th. Sorry,
April 6th. You're
right. I'm getting my Marches and my Aprils mixed up. Okay, so April 6th. How's that look?
Yeah, we would just need everything in before March 13th, 12th, 13th.
Okay, that sounds like enough time. Mr. Bunsick, how does that sound to you, the April 6th meeting?
I do believe that sounds like enough time for us. I'll contact my surveyor as soon as possible.
All right. Okay. With that, Mr. White.
Madam Chair, could I ask, I have no problem with the deferral to whatever date. Could I ask if we could request staff investigate the issue with respect to the registered site plan agreement and the need, if any, to amend that agreement that is registered on title, and what the process would be if it's required to do that? Because I think that's a significant thing that we maybe not addressing here that should be addressed. And
Okay.
also, if I could add, if we could get some more clarification with respect to staff's preferences with respect to vehicular access, either Avignon or Jeanne d'Arc.
Okay, so, and I think as part of the easement that we're going to be looking at, I would hope that we're working some of those things out and that we'll have some of those answers when it comes back to us. It's part of understanding how the functionality of the site and the access is on the site. So that's a very good point, Mr. White. So subdivision agreement and looking at what the impacts of those things are, looking at the placement of the easement on site and understanding the sort of the pros and cons of Avignon versus Jeanne d'Arc as the access and egress points, right? Okay.
Yes, I think the subdivision and/or site plan agreement that might be registered on title there.
Exactly. It's probably a site plan agreement. You're right. Okay, so with that, then I think I just want to explain to the audience that we are looking at because of this maintenance access, and it's been raised by Monsieur Pierrier and Mr. Summers. I think you raised it as well. We're going to be exploring that further. We're hoping that traditionally the right way to do that is to ensure that you have easements that are granted to benefiting owners, and in this case, it would be the existing owner that would be in the townhouse, the right to access the rear yard and through their abutting owner. So that's going to come back to us on April 6th with an application. It's an application for consent, but in that case, it's not an actual subdivision of property. It'll be the addition of the easement to this application. I think that'll be the right way to do it, is that we're just going to amend this application to include the easement. Okay. All right. With that, then, I'm going to go to a vote. So it's a motion to adjourn this particular item to April 6th. All those in favor? All right. For the record, the decision is unanimous. Mr. Bunzik, we will see you back in about a month and a half. Actually, yeah, about a month and a half, maybe 6 weeks or 7 weeks. And we're looking forward to seeing that draft plan that shows the easement.
Thank you, Madam Chair. Have a good night.
All right. Thank you. Have a good night, everyone. So just taking some notes to myself to make sure I don't forget this. Okay. All right. So that's another application for adjournment. We're doing really well on the adjournments tonight, folks. Okay. All right. We're going to go to our fast track applications at this point. I'm going to go with number 1, which is for 20 Rabina Avenue. And I'm looking for Mr. Campbell, I believe. Yes, Mr. Jonathan Campbell.
Hello.
Hello.
Hi.
Good evening. I'm going to need to read to you because we don't have a statutory declaration about the sign, so I'll read this to you. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that the sign was at all times visible and legible? Do you either swear or affirm that to be true?
I affirm that to be true.
Thank you very much. That's perfect. So we've taken care of that little piece of business. Just one other little piece of business before we get into to questions. I believe that we're amending the minor variance request by doing the following. I'll read this to you and you can just confirm to me for the record that it's okay. The owners require the authority of the committee for a minor variance for the zoning bylaw to permit an increased deck projection of 3.35 meters into the required rear yard. We're striking, and 5.7 meters from the rear lot line. Whereas the zoning bylaw permits a maximum projection of 2 meters into the required rear yard, and we're striking, and no closer than 7 meters from the rear lot line. Is that right?
That is the document that we saw. Yes, that's what it says.
Okay, all right, can you confirm that makes sense to you and that you agree to that change?
Well, I mean, the wording was very confusing. Basically, we're looking at our deck projecting just over 3 meters instead of only 2 meters. So I think the issue is that it's a little, that it's a meter and a bit too close to the back line, because we're supposed to be 7 meters away from the back property line.
Okay, I think these actually improve the language of the notice.
Okay.
So I think if you're not opposed to it.
We're not opposed.
Okay. Okay, we'll go with that. We'll go with that. So that works. All right, so we don't need a presentation from you this evening. We've looked at the application. It's fairly straightforward. I'm going to open it up to questions from the committee. Does anybody have any questions regarding this proposal to permit an increased deck projection into a rear yard? All right, I'm not seeing any questions from the committee, so I'm going to open it up to the public. I don't have anybody on my speakers list. Is there anyone in the audience who would like to speak either for or against this minor variance request proposal for this deck, an increased deck projection? All right, I'm not seeing anybody come forward, so no comments from the public on that. We can go to unless there's questions from the committee, we can go to a vote. All right, all those in favor of this minor variance application? All right, for the record, the application is granted unanimously, and I think there's nothing left really to talk about your application. It's granted, so we're going to wish you luck with your project.
Okay, thank you.
Thank you.
All right, thanks so much. Okay, the next one on the docket is application number 4 for 183 Britannia, and I'm looking for, on this one, application number 4, Mr. Chichetto.
Hello, I am here, and allow me to start my video. And hopefully you'll see me now.
Yeah, we do see you. That's great. Thank you very much. I need to read something to you. No, we didn't get a statutory declaration from you, so I'm going to read. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I affirm that to be true.
All right, thank you very much. No presentation required from you this evening, so opening it up to committee members. Any questions regarding this proposal for minor variance? We've got 3 minor variances, no housekeeping matters. Anything from the committee? No? All right. I don't have anyone on the speakers list, so I'm going to open it up to the public. Is there anyone in the audience who would like to speak either for or against this application? Now's your chance. All you need to do is raise your hand. All right, I'm not seeing anybody come forward. So committee members, if you don't have any comments or questions, we can go to a vote. All those in favor of the application? All right, for the record, the application is unanimously granted. Thank you, Mr. Chichetto. I don't think we have anything else we need to discuss. All right, thank you. All right, next application is number 6. Looking for, and this is 37 Tower Road, Mr. Segreto. Okay, Mr. Segreto is back. Hi again.
Hi.
No presentation required from you tonight on this particular application. Don't have any housekeeping, but before I go any further, I'm going to need to read to you. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, or that it was clearly visible and legible during the entirety of that time? Do you either swear or affirm that to be true?
I swear.
All right, thank you. Okay. Questions from the committee on this application? To Mr. Segredo, anything? All right, I'm not seeing any questions from the members. I do have somebody registered to speak. Actually, I have three people. I have Ms. Nancy Wilson, I have Ms. Jill Pratt, and Mr. Peter Aruja.
Good evening, Madam Chair. This is Nancy Wilson. I'm going to be speaking for all three of us tonight because we've sort of shortened it down. And Peter's just here as an observer tonight. So good evening, committee chair and committee members. First thing I'd like to talk about is the new OP. We'd again like to remind the Committee of Adjustment and the planners and the applicants that any provision under the new OP will not be considered, should not be considered until such time as required secondary plans and new zoning bylaws are enacted. With respect to this application, the main concern that the City View Community Association has identified is a request for a corner side yard variance. Side yard variance. The committee of the City View Community Association objects to the requested variance for the reduced minimum side yard setback of 3 meters when a 4.5 meter minimum is required. This is the side of the new building that faces the street and will allow this new building to extend further past the existing houses on most of the Pender Avenue. But by keeping the setback to the allowed 4.5 meters as required by the bylaw, this would meet the streetscape with the streetscape and character of the neighborhood. The planners claim that the zoning bylaw establishes patterns of corner side yards in neighborhoods. Corner side yards separate buildings from the public realm and provide areas of soft landscaping and trees. Soft landscaping is encouraged for this aesthetic and environmental value. Yet by supporting these corner side yard variances, these opportunities for public separation, soft landscaping and trees are greatly reduced. This is not minor. Staff has also strongly recommended the owners of the plant to plant a row of hedges or other greenery along Pender to visually screen the proposed building and demarcate the public and private realms. We assume that this row of screening is being recommended for the benefit of the adjacent residents. We suggest that if this proposed building is at the required 4.5 meter setback, the impact of this building would be lessened and such provisions may not be needed. We're asking that the footprint of this new construction be reduced so that this proposed corner side yard setback is not required. And we've had discussions with Mr. Segretto's people. We did get in touch. Mr. Segretto did get in touch with us, which we greatly appreciate. And we've discussed some of these things, so that's a good thing. The trees, we note that the trees on this lot were all removed several years ago. This can be seen on GeoMaps. This empty lot has been listed for sale for several years. The planner strongly recommends the planting of one new tree, 50 millimeters, in the right of way of each lot to improve the streetscape and the urban tree canopy. In the planner's report for 2 David Drive, the planner says that this is a different planner, but one planner says that they strongly recommend. The other planner says that they shall be planted. So we're just looking for some consistency there when these things are suggested to us. In any case, a tree cannot be planted in the city's right of way in City View because this is where our ditches for drainage exist. In fact, it is illegal to plant on the city's right of way here. This is why we work so hard to protect our tree canopy, as most of our trees are on our properties. We are unlike other communities with storm sewers and curbs that allow for tree-lined streets. The soft landscaping of the front yard, about this total aggregated soft landscaping of the front yard, we were confused about the change in numbers from the old site plan and to the new revised one, but we did resolve this with the agent yesterday, sorry. Inclusion of the garage and calculations of lot areas. We have a question about this. On the revised site plan from February 8, 2022, we note that the lot coverage for this new build and the existing building are 32.8 and 42.2%. These lot coverages are clearly indicated along with their calculations by the blue dotted line. They indicated areas included that are included as the interior garage areas too. We are confused because in the past, in other applications, recent applications, we've been told that the garage and porch areas don't count in the lot coverage areas. So again, it's an inconsistency. We're not sure if the garages count or the garages don't count, or it's just whatever anybody wants. Lot widths and sizes, compatibility with the existing context. The planner claims that on this segment of Tower Road between St. Helens Place and Pender, there are 15 other dwellings where the front wall faces Tower Road. The planner further claims that the street frontage of lots ranges from approximately 19 meters to 30.6 meters. The lot areas range from 521 square meters to 839 square meters. Yet this application is proposing lot widths of 15.57 meters and lot areas of 450 square meters, well below these quoted in the comparisons in other lots in this block. As the planner notes, when lots become narrower and front yards become smaller, it is more challenging to maintain the street's character of landscaped yards and accommodate all of the uses typically included in the front yard. Pender Street is a pleasant road lined with mostly shrubs and hedges. In reviewing the streetscape along Pender Street, the planners reference 51 Chippewa, which is at the corner of 8 Pender, and 49 and 51 Lotta Avenue as corner properties that will be intensified or that have been intensified. We could not locate plans for 51 Chippewa, but it appears that there's no variance on the side yard facing Pender. However, the corner lot on Lotta and Pender was approved for a reduced easterly corner side yard setback of 2.93 meters. This now constructed building clearly does not fit with the streetscape and the character of the rest of the neighborhood. This same mistake should not be allowed to happen again. About the 4 tests, the committee is authorized to grant minor variance if all the 4 tests are met. City View Community Association reviews each application along with the city planner's report and tree report to ensure that the information is complete and accurate and that meets the zoning bylaws, and each infill is appropriate development for our community and height and character. The addition of the corner side yard variance is not desirable for the appropriate development of the property in this case. The variances are not minor. The general intent and purpose of the zoning bylaw are not being maintained. Infrastructure, the city staff are well aware of the lack of storm sewers in City View and the importance of maintaining the integrity of the existing rural ditch system for drainage. In recent discussions with the City of Ottawa, we were advised that ditches and culverts under driveways are a requirement of construction in City View. Conditions should be included to ensure that the existing drainage ditches on both Tower and Pender Street are retained and culverts are installed under the driveway. And this comes from the site alteration bylaw 2018-164, section 7. I don't need to read that to you, but it's there. So yes, we'd like to thank you for listening to our concerns and our suggestions. Thanks a lot.
Thank you, Ms. Wilson. Your comments are always so knowledgeable and well-informed and thoughtful. We really do appreciate the time you take to presenting to us. With that, I'm going to open it up to the committee's members to, if they have any questions for you. Anyone? For anyone? Okay, thank you. Then I won't go to the other 2 speakers then, because Ms. Wilson, you indicated that you spoke for them. I do have additional speakers, though. I believe Mr. Gervais, Doug Gervais from 22 Bain. No, I'm sorry, I've got that wrong. I'm looking at the wrong application. Sorry. It was, again, with the same community association, the same area, but the wrong application. So number 6. Where are we with number 6? No, I think that was it then. Okay. Is there anyone in the audience who I don't have on my list who would like to speak to this application, either for or against? Now's your chance. All right, I'm not seeing anybody come forward. So just like to explore a couple of things then that Ms. Wilson did raise. And I guess I'm looking for Ms. Young on this. I think, and I am seeing here in the additional comments where it's, or actually just before the additional comments, it's that staff strongly recommends that the owners plant a hedge of rose and greenery. And also, yes, it is, again, in the additional comments, strongly recommended to plant one new tree in the right of way for each lot. Can you tell us when is it a shall and when is it a strongly recommended? What's the difference?
Generally, through you, Madam Chair, generally I'm recommending or strongly recommending tree planting where it's a minor variance and requiring where it's a consent. I didn't catch the address that Nancy mentioned, so I don't know where that is, but if it is, if I've done something different for another one, then that's my mistake.
That
anyway.
does make perfect sense. So Ms. Young, now that you say that, we can condition consents, and in that case, we can be more prescriptive and we can say shall. And when it comes to minor variances, we have additional comments or not conditions, and there we strongly recommend. So I hope, Ms. Wilson, that helps in your question. It was a good one, and it's one that I now have much greater clarity on, and I probably should have before, but at least I now it's quite clear. The other
thank
question,
you, Madam Chair. Thank you, Madam Chair, for that. It was 2 David Drive, and they did have a consent, so that's why they could say shall. This one is recommend. So that makes perfect sense to us. Thank you.
All right, thank you. And then I guess the other question I had to do with the lot area, I guess. Actually, I was thinking, Mr. Segreto, in looking at the way that you have the corner side yard down to 3 meters, can you tell me whether or not it would have been possible to design a house to meet the 4.5 required setback? I believe that's what it is.
We've done the 3 meter corner side yard setback on a number of houses in this particular neighborhood. And the reason for that is basically it gives us a chance to have a little bit of a wider entrance when we enter into the single family dwelling. And that's the only reason why. If you reduce this thing by another 5 feet, it makes it a lot more difficult for us to come up with a design for the front entrance. The other option would have been as to have the corner side yard at 55 feet rather than 50 feet, and have the interior lot at 45 feet. But I believe that the community doesn't want to see 45-foot lots in there. I've seen that happen in this area as well. But that's one of the reasons why it just makes a much more desirable front entrance for the single family dwelling. And as I said, there's about 4 or 5 other examples that have been approved in the past with the 3 meter corner side yard setback.
All right, thank you, Mr. Segreto. Just wanted to get an answer on that. And my last question then is to Ms. Ramirez, and it's to explore again something raised by Ms. Wilson. About the lot coverage calculation. My understanding is it does include garages, but not necessarily porches. Can you just lend us some clarity on that?
Thank you, Madam Chair, for the question. And you are correct that it would include the garage, but not permitted projections.
All right, okay. Porches are permitted projections, so, but anything that actually is covered and is enclosed, that then does get covered. It does get included in the lot coverage. Okay. Yeah. And I hope that's more helpful, Ms. Wilson, as well.
It is more helpful, but it just raises questions about the few that were in the last few weeks that we were told that the garages weren't included, but that's nothing we can do about it now. Thank you. We'll watch for it.
All right, thank you.
Madam Chair, if I could.
Yes, go ahead.
Just for clarification, when we say porches are not included, I'm assuming that if the porches are enclosed, in other words, they're fully covered and enclosed with walls, that they are included in the lot coverage calculation. that correct?
Madam Chair, if I can address Member White's question, if it is fully enclosed, then it would no longer be a permitted projection, it would be an addition.
Ah, I see. Okay, and that makes sense as well. Okay, thank you. All right, I think that's it in terms of the questions I had. Mr. Handel, go ahead, please.
I just had a question for Mr. Sagrado. I was looking at the hydro comments in this case, and they do mention not necessarily concern, but they flag the setback from the wiring that's on the side yard of this property, which does include potentially up to a 5-meter setback from the hydro installation. Given that you're requesting a 3-meter side yard setback in this case, have you looked at that and the impact that it may have on the built structure?
We have in the past. That normally comes up. It's a 5-meter radius that you have to have from the hydro lines to the height of the roof, I guess it is, from the slope. We've looked at that. At this particular case, we don't anticipate any issues. And we will be meeting with hydro on site, but we don't anticipate any issues at this time.
Okay, so you're confident that given that you'll still be able to meet the kind of 3-meter side yard setback in this case that you're requesting?
Yes, I do.
Okay.
Thank you.
Thank you.
Okay. Any further questions? I think I already made a call out for other people to speak, right? Did I miss that? So just remind me, did I miss that? Getting late. It's getting late. Okay, if there's no other questions, then we're going to go to a vote on this. So all those in favor of the application for minor variance? All right, Mr. White, you're dissenting.
Madam Chair, if I could just comment, as you know, I have a fundamental issue with the general purpose and intent of the setback or the lot frontage, lot width and lot area requirements provisions in zoning bylaws as it stands today. In their presentation, Ms. Wilson did point out that the local context here, the street frontages are significantly above the what is proposed by this application and by the number of other applications that we have seen in the area. So in this portion of the community in particular, it's my view that it's not consistent with the compatibility and context of the local community. Again, I still am not satisfied that the general purpose and intent of the zoning bylaw is maintained by the minor variances to the extent that they're proposed here and as they are proposed in a lot of other situations that we've been dealing with. Thank you.
All right. Thank you, Mr. White. Okay, so with that then, for the record, we have 4 in favor. So the application succeeds and is granted with a dissent for the reasons Mr. White has just outlined. So I think that's it, Mr. Sagrado, on that application.
Thank you so much. Thank you.
All right, thank you. All right, we're going to application number 7 and 8 for 844 Connaught Avenue Holdings, looking for Mr. Kelly.
Good evening, Madam Chair, members of the committee.
Good evening, Mr. Kelly. So on the statutory declaration, going to need to read something to you.
Absolutely.
All right. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first on the property to which the application applies? Secondly, that it was there for the prescribed number of days prior to the hearing? And lastly, that it was visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I do swear.
All right, thank you. In terms of, I don't think there's any housekeeping items that we need to take care of on your application. We don't need a presentation this evening. So we're going to open it up directly to the committee members for questions. Any questions by the committee for Mr. Kelly on this application? I'm not seeing any. Okay, we're going to go to the public portion on this application. I do have some speakers that are registered with us this evening. The first I have is Ms. Vandergrift. All right, go ahead, please.
Good evening. My name is Kathy Vandergrift. I live at 937 Alpine Avenue in Queensway Terrace North, which is this neighborhood. I also serve as president of the Queensway Terrace North Community Association. Queensway Terrace North is a neighborhood with mixed housing, and we value that. We support infill that fits in the context, and I noted the comments in the previous presentation with that regard as well. That has to mean much more than just how many other similar buildings on the same street, which we tend to see in the planner's analysis. In fact, sometimes that's why something different is valued. In this case, the house that's on this site is known and deeply loved as the Gnome House because it is unique. So sometimes having something that's different is in fact preferred to having everything the same as seems to be advocated. We do want to note some things we appreciate. In this case, the designs is done with the site in mind in a better way than we have seen in some others, and that's appreciated. We also appreciate that the garages are going to be wide enough that they could be used for parking, not just storage, as we often see in our neighborhood. Residents in the immediate area shared us three main concerns with this development, in addition to those that we mentioned as appreciation points. First of all, there is a concern about maintaining the green space close to the streets. So the residents share the concern that is cited by the city planning report. That the variance in terms of the corner side yard and the green space adjacent to the street. We note that the planning department has suggested an alteration in the site plan that would in fact allow for the interior lot to meet the 30% soft landscaping and improve that sense of green space with the street. I think the residents would be in line with what the city planner is naming as an issue there. The second concern that gets raised is trees. We do appreciate that there are plans to retain the trees on the city property. The third one is we are wondering if conditions can be added to ensure that the green space cannot be converted to parking later. This happens frequently in our neighborhood and with applications like this because there is inadequate parking spots for the 4 units. We know that the city does not require parking spots for secondary units, but the reality is that we see yards turned into parking for these. Then we have to complain to bylaw enforcement. It's a long delayed process. Is there any way that conditions can be put on the application from the beginning to prevent that from happening, particularly given, as I said, the concern about the green space with this application? Thank you.
All right, thank you for your comments. All right, so I've got 3 main issues. There was the landscaping. There was a condition for, generally the landscaping requirement, but also a condition to protect the landscaping. And the second one, Ms. Vandergrift, if you could just repeat it for a minute. I had it in the...
Well, I was reporting to you that there were 3 concerns by the neighbors. It was the green space. The neighbors are concerned about the trees, but I see those are addressed in the tree report from the city, and that feels satisfactory. And then the third one was the condition to prevent change in the future from the green space to parking.
All right, so trees I forgot, so that's good. Thank you, I've got that now. So perfect. I will go then to the next speaker, which is Ms. Blakeney. Go ahead.
Thank you. I've got a number of observations and questions. So I'm just going to quickly go through them. I question whether or not the site plan needs to indicate projections like decks, because there are none showing in the plan, which I find odd. And that's been a bone of contention with residents in the past. Does the Committee of Adjustment need a variance application for a change of civic address? In the city planning report, it uses a Sackville address. And as we've seen from the plan, the driveway and the main door or the front door are on Sackville. They are not on Connaught. And in general, it's hard to envision what this property is going to look like, because with the twist of where the front door is on Sackville, I don't know what the front of the property is, if it's Sackville or if it's Connaught, which then raises a question of streetscaping, the characteristics. I'd also like to confirm that there is no easement on this property. There is an easement showing on the property to the north, and then it just ends at this property line. And also, once again, because there are no variances with respect to the dwelling being proposed or envisioned, that there is no variances required for elevation, width, length of the proposed dwelling. And a question as to whether or not the developer's site plan is supposed to be the same as a city planning site. In this case, it's a question of the trees. On the developer's plan, they show 2. On the city, they show 6. Really, there's 5. And then a question of, I guess it's process. The city planner, as Ms. Vandercryft mentions, has requested some changes to the interior lot site plan. And has this been done? Does that mean that a new or revised application is needed? And like Ms. Vandergrift has mentioned, also happy to see the emphasis on soft landscaping raised by city planners. But it does raise a concern, and I'm going to probably kick myself for saying this, but if the, with all the soft landscaping, there's a concern for access to the secondary dwelling unit, because basically you have to walk over the grass to get to that secondary dwelling unit. So I'm not sure what that's going to look like after a few weeks of back and forth over that. And once again, with no real details on the design, I don't know where the doors are. I don't know if there's going to be a back door on Connaught, if there's a back door on Sackville, along with the main entrance. I'm not sure if we can ask for that kind of information. Thank you.
All right, thank you, Mrs. Buckney. Mr. Kelly, there was a lot there that was raised. I think I'm going to, oh, and I'm seeing Mr. Chown's hand up. So maybe Mr. Chown, are you willing to take a try at responding to a number of the issues raised by Mrs. Blakeney?
Madam Chair, it might assist the committee if you would allow us to put up the site plan that's part of the presentation package that Mr. Kelly provided to the committee coordinator. I can reassure the two community members that the site plan that is before you now has been revised to address the comments raised by the city planner with respect to the soft landscaping for the interior, for the front yard of the interior lot or the interior unit. The plan that's before you illustrates where the principal entrances are and where the secondary entrances are. They are accessed by pathways from the street and from the driveways. And just in terms of the orientation of the corner unit, I think that corner units present tremendous opportunities to design a building that looks like a single family home on both elevations, where you have the front door and one front door and one garage facing Connaught, and one front door and one garage facing Sackville. It's a fantastic opportunity for innovative design for a semi-detached dwelling. Madam Chair, unless you want us to speak to any of the other specific questions, I'll leave it at that.
Well, there was a question on trees, Mr. Maybe if we actually coordinate, if you wouldn't mind leaving that site plan up, because I'd like to just talk about the tree situation for a minute. There was some concerns about, so if you can just tell us what's, without reiterating what's in the planning report, what trees are being retained, what was in your tree information report, because I'm seeing a plan that's from a report that was submitted. So if you want to just walk us through that, Mr. Chown.
So I apologize, we haven't included the plan from the TIR in our presentation materials, which obviously would assist the committee. But the TIR is included within the staff report, and it clearly identifies the 4 trees. Actually, there's more than 4. There's 5 trees to be maintained and 1 to be removed.
Okay.
I'm sure Ms. Young can answer any questions with respect to the TIR.
All right. I see there's no tree-related concerns from the city's perspective with regards to that. None of the existing trees are expected to be impacted by the proposed construction. So I'm hoping that that's helpful to our members of the public who spoke, because that's what I'm gleaning from this report, that in fact we do not have a tree issue. So in fact, there'd be quite a few trees if you've looked at the tree information report that will be provided. Okay, there was one other concern from Ms. Blakeney, I believe. Two others actually, that one is no easement on the property. And so I didn't look at it that closely myself, but can you speak to why there's no continuation of an easement? And the last one is with regards to, is there a requirement for minor variance to deal with issues regarding municipal addressing? So Mr. Chown, yeah, you can answer those if you would, please.
So municipal addressing has nothing to do with the Committee of Adjustment decision-making process or minor variances. The municipal addresses are actually assigned by Building Code Services. And with respect to the easement, the legal survey we have for the subject site simply doesn't show an easement on the property. I can't have no knowledge of the easement on the abutting property, but the survey for this property does not show an easement.
All right, and there's no requirement for one either. Correct, Mr. Chown?
No, and just speculating if it was a utility easement, we have no comments from either Bell or Hydro or any of the cable companies looking for an easement.
Okay. We do have comments from Hydro Ottawa, however, that says that a 1.2 easement be granted to Hydro. So there will need to be an easement for Hydro. Have you read the comments that came in from Hydro Ottawa?
Jeff, I've got no issue with it. Jeff, you're familiar with that condition or request?
That's correct. Yeah, it's a 1.2 meter easement for Hydro Ottawa for existing overhead distribution lines at the rear of the property.
All right. And I suspect that might be, and I don't know the condition of the easements on the other property, but maybe it's related in some way. But in any event, at least we're going to capture that portion. So that responds to, I think, most of the comments that have been raised by our speakers. I'm going to open it. I don't have anybody else on my list, but I'm going to open it up to the public at this point. So is there anyone else in the audience who would like to speak either for or against this application? Actually, either the application for consent or minor variance. All right, I'm not seeing anybody come forward. So any further comments or questions by the members of the committee, or do you want to go to a vote? We can, if you don't have anything else that you'd like clarity on. we can go to a vote on the consent and then a vote on the minor variance. All right, let's do it. Then on the consent application, all those in favor? All right, for the record, the consent application is unanimously granted. On the application for minor variance, all those in favor? All right, for the record, the minor variance is also, or minor variances, plural, are granted as well. So with that, there are a number of conditions that are attached to the consent application, as you know. And any questions about any of those? Mr. Kelly, Mr. Chan?
Not at this time, no.
All right. Okay, well then with that, thank you for your time and your applications are granted.
Thank you very much.
Thank you very much.
All right, thank you. Okay, on application, the next one we're going to is application number 11, which is for 1243 and Anoka Street. Or Anoka, maybe my emphasis is in the wrong place. And I think I'm looking for, on number 11, the agent would be Ms. Garbos. Good evening.
Good evening, Madam Chair.
I do believe that there's no statutory declaration in for your application. So going to need to read something to you and get you to respond. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear that to be true.
All right, thank you very much. And I believe that's it for the housekeeping. I don't need it to do anything else. No presentation required from you this evening. We've had a look at the file and all the material in the file. So I'm going to open it up to our committee members at this point. Anyone with any questions? Not seeing anybody with any questions come forward. That's okay. We're going to go then to my speakers list, and I do have somebody registered. I'm looking for a Mr. Cherian.
Oh, hi. Sorry about the late.
That's all right.
Yeah, so I just have a couple of questions regarding the tests. One is with 4 units being built on this dwelling, what steps will be taken to ensure adequate parking and garbage removal for this number of occupants and space for snow removal, as the driveways will take up most of the frontage? Currently, parking is only allowed on one side of the street and there are no curbs on our street. Often cars end up parking on the front edge of lawns, causing damage. Sorry, I should say I live at 1252 Anoka, and my name is Matthew Cherian. My second question is, how does this application address the loss of sunlight, privacy, space, openness with the neighboring houses being quite close, with one neighbor's driveway connected to the applicant's driveway, as is typically found in our older neighborhood? And then my second has to do with the general intent and purpose of the zoning bylaw. So my overall concern is this is the third such dwelling being erected in our neighborhood. That is a 4-unit dwelling built into 2 semi-detached homes with minimal frontage. That will lead to a change in the streetscape and character of this neighborhood, this older neighborhood. As well as, to my understanding, the applicant intends to rent out rooms by the room, similar to other recently built dwellings in our neighborhood. So again, how does this application address this test of keeping up with the streetscape and character of the neighborhood? Thank you.
All right, thank you, Mr. Cherian. That's quite a lot of information, so that's good. All right, a couple of things. I'm going to actually call on Ms. Ramirez just to get some clarity on a couple of things. So I think we can respond to a number of your concerns fairly quickly. In terms of adequate parking, Ms. Ramirez, just remind us, what is the parking requirement for this type of development?
Thank you for the question, Madam Chair. one parking space is required for each of the principal dwelling units, but the secondary dwelling units are not required to provide parking.
All right. And in those cases, they're as of right, the secondary units, are they?
Yes.
They are.
Yes.
Garbage collection then is normal municipal pickup, correct?
Yes.
All right. Snow clearing, same idea, because it's no more than as if it were two dwellings. Snow clearing is as it would be in any residential neighborhood, correct?
Yes.
Okay. And with regards to questions to solar access, light, impediments, what have you, we typically don't undertake that kind of analysis for this kind of development, correct? There's no requirement as part of the application process.
That is
All right.
The building complies with the setbacks, which is where we would look at those types of issues.
All right, thank you. And just to be sure that we don't have the information regardless, Ms. Garbos, if you could just confirm whether or not you've done a solar access or light impediment or any other kind of massing impact on surrounding a neighborhood and the character as part of your analysis.
I can confirm that I have not done a sunshade analysis as part of assessing the fit of this new development in the neighborhood, but I will reiterate what Ms. Ramirez had said, and that it is compliant with all of the setbacks as well as the other performance standards such as height for the zone.
Exactly. So it is, in fact, there is no requirement to reduce height in any way because you're in compliance. So you're in conformance with the zoning bylaw, and typically, Mr. Sherigan, we do not require the kind of analysis that you're requesting unless it speaks specifically to the element of minor variance that's required. And in this case, height is not one of them. All right, I just wanted to be good. You were very good, Mr. Sherigan, in terms of being able to identify a number of different issues. And but I think these issues are fairly straightforward. Ms. Garbos, did you want to comment further?
Yes, Madam Chair. I did hear a question related to renting by the room. In such a situation, that would be a rooming unit situation, which is not what we're proposing here. So it is 2 semi-detached units with secondary dwelling units in the basement. And there are 2 incidences in the zoning bylaw that prohibit rooming units. One is in the R2 zone itself, stating that the properties that front onto, I believe, is a collector road, can permit a rooming house. And because Anoka is not a collector, that use isn't permitted. And then secondly, in the secondary dwelling unit provisions, where you are providing secondary dwelling units on a lot, you're not permitted to provide rooming units.
All right, thank you for that. That's helpful.
Yeah, thanks for that. Thanks for that clarification. Appreciate it.
All right, thank you. Okay, I don't have anybody else on my speakers list, so I'm going to make a call out. Is there anyone in the audience who wants to speak either for or against this application? Now's your chance. Okay, I'm not seeing anybody come forward. So I think, members, if you're ready, we can move to a vote on this application. All those in favor? All right, for the record, the application is unanimously granted. Thank you very much.
Madam Chair and committee.
Right,
Have a good day.
The rest of the evening.
Thanks.
Not much left. Okay. All right. Let's go to number 12. This is for 1321 Fernwood Drive, looking for Ms. Harris. Ms. Harris, good evening.
Good evening.
All right, so I think we need to read to you as well and get a response. So, do you solemnly swear or affirm that the notice provided to you by, as part of the application process and by the committee was posted first on the property to which the application applies. Secondly, that it was there for the prescribed number of days prior to the hearing, and that it was at all times visible and legible. Do you either swear or affirm that to be true?
Yes,
Can you affirm or swear, please?
I do. I swear.
Thank you very much. All right, no presentation required from you on this application. Our understanding is that some works went ahead and that we're doing a little bit of catch up here tonight with regards to the legalization of a secondary dwelling unit in the basement. Okay. Any questions from the committee on this? Mr. White, go ahead.
Thank you, ma'am. Just a quick question. I'm wondering if the conversion or the introduction of the secondary dwelling unit required any outside works? In other words, was there an extension of the building affecting the exterior? Was it all interior works to create the secondary unit?
Would you like me to answer?
Yes, please, Ms. Harris.
Oh, thank you, Madam Chair, for the question. We haven't done any work on the basement yet, and we're not proposing to do any exterior work. The basement secondary dwelling unit is already existing. If this were to be approved, we would then be bringing it up to code.
I'm just wondering, is there any, with the building that was built, with the secondary unit that was built, were there any outside works associated with that beyond what the original building incorporated? Or was there?
Not to my knowledge, no, because the entrance from the basement was pre-existing when the building was built.
So the secondary dwelling unit then only involved conversion of existing interior space.
Correct, yes.
Okay, thank you. Madam Chair, just a question to staff. Wondering about the only issue we're dealing with here is the reduced lot area, or sorry, lot width. And I'm wondering if this issue arises, and this is to staff, this issue arises simply because there was a difference in the Gloucester zoning bylaw in terms of how lot width was calculated and wasn't carried over to the City of Ottawa bylaw when the bylaw was adopted. Because I imagine that there are a lot of other examples, a lot of other lots that will have the same issue with respect to lot width. That's all we're dealing with here.
Through you, Madam Chair, the lot width is a result of the measurement that is in the bylaw currently. I'm not sure if it was what the Gloucester bylaw specifically stated to the lot width measurement, but I do note in my report that there are other lots with nearly identical shapes that would also require lot width if they were to have a secondary dwelling unit in this case.
Could I suggest that this might be appropriate to put on the list of issues that should be addressed with the review of the zoning bylaw following the official plan adoption, Madam Chair?
Absolutely.
A number of these situations where we have to deal with lot widths and lot coverage, or sorry, lot frontage, lot width, lot area issues that don't really relate to the construction that we're dealing with in terms of these minor variances.
Yeah, I totally agree, Mr. White. So that's again, part of our committee of the whole's discussion that we try to have with the planning department when we run across these kinds of things it's a lot of other properties could be subject to this too, and it doesn't make sense, and maybe not. So, but it's worthwhile to still have that discussion and find out what the rationale is.
Well,
maybe we're missing something.
It would save a lot of applications of committee adjustment if these issues were dealt with in the zoning bylaw.
I agree. Okay. Any further questions? All right. Did I go to the public yet on this application? I don't think so. So I don't have anybody registered for this to speak to this item, but I'm going to make a call out. Is there anyone in the audience that would like to speak either for or against this application? Just raise your hand. Okay, I'm not Not seeing anybody come forward. So with that, then I think we can go to a vote. Members of the committee, all those in favor? All right, for the record, the application is granted unanimously. All right.
Can I ask
Thank you
a
very much.
question?
Yes, go ahead, please.
I would just like a little, I have watched the past committees, but I'm still looking for a bit of clarification if this decision is final or it's half final and I then need to wait for the 10 days.
It is final in the sense that I've never seen the committee ever reverse their decision, and I don't think we can. I think once it's on the record, Ms. Harris, it's on the record. It's our decision and it's an approval. The written decision simply outlines the rationale.
Okay, thank you, Madam Chair.
Madam Chair, there is an appeal process if possible.
Yeah, there is. That's true. I guess the question, if I understood then, Ms. Harris, though, was whether or not between now and the written decision, we could change it. But there's always the appeal, whether you like it one way or the other, then you can still appeal it. If you agree with it, don't appeal. If you don't agree with it, you can appeal. All right.
Okay, thank you.
Hope that helps. I don't know, maybe I confuse things. Thank you so much.
No, that's good. Thank you. Good night.
Have a good evening. Okay, we're on to number 15, 302 Leggett. I'm looking for Mr. West.
Good evening, Madam Chair, members of the committee.
Good evening, Mr. West. I do believe I need to read something to you. All right. Do you solemnly swear or, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
Do swear.
All right, thank you very much. Okay, I don't see any changes to your application from a housekeeping standpoint being required. So, all right, and no presentation required. I'm going to open it up to the committee members for any questions. Any questions at all on this application? All right, I'm not seeing any of the members come forward with any questions. So it's a granting of an easement and a right-of-way. All right, so fairly straightforward. With that, then I'm going to go to my list for, and I don't have anyone registered to speak to this item. So with that, then I'm going to open it up to the public. Is there anyone in the audience who would like to speak either for or against this application? Now's your chance. And I do actually, I'm not seeing anybody come forward, for the record, but I do, you know what, I just noticed that there might be a requirement for housekeeping amendment. So is it possible that we need to add reference to 232 Hertzberg Road? Was it on it?
Madam Chair, I'll defer that question to my colleague, Mr. Chown.
Okay, but just let me catch up here for a minute to see whether or not it's in here. Yeah, no, I'm not seeing it. I guess it's not a notice, a modification, but just an acknowledgement, I guess, that it affects 232 Hertzberg. Okay, sorry about that. I just want to make sure it wasn't a notice amendment. Okay, Mr. Chen.
So thank you, Madam Chair, and that's what I wanted to speak to. I just noted in the memo to the committee from staff, they have suggested that the easement should be granted in favor of both 103 Schneider and 232 Hertzberg. That amendment is not necessary. In fact, it would be inappropriate. The easement being sought is not in favor of 232 Hertzberg. They have their own drainage outlet. So for the record, the easement being sought is in favor of only 103 Schneider.
All right, and I just want to get our staff then brought forward. Who's which part? Ms. Ramirez. Can you explain why you were adding that particular municipal address?
Thank you, Madam Chair. I added that particular address because that is the land on which the stormwater infrastructure also runs over. There was a committee of adjustment application that went to panel 3 in November, and easement was granted over 232 Hertzberg Road for the benefit of 103 Schneider. And so the stormwater infrastructure runs over 232 Hertzberg Road, and it is for the benefit of 103 Schneider. And so since that infrastructure runs over that property, that's why staff suggested that the notice be amended to also include that property.
Would there be any objections to that, Mr. Chow? It would be just an abundance of caution kind of amendment.
Well, the applicant has not agreed to provide an easement in favor of 232 Hertzberg Road. There have been no discussions between the applicant and the owner of 232 Hertzberg about providing an additional drainage outlet to them when they don't need one.
But I guess that maybe it's me. I had understood it's already there from a previous application. Is that correct, Ms. Ramirez?
So we can put up a figure from Mr. West's presentation that might help the discussion. An easement has been created over 232 Hertzberg. A drainage easement over 232 Hertzberg has been created and approved by panel 3, where 103 Schneider is the benefiting owner of that easement. So the easement being created tonight is the final piece of the puzzle. So this image, if you can look carefully, just below the easement that's part of the application today is another part on the underlying reference plan, which is the easement that was granted by panel 3. So the drainage from 103 Schneider is going to run along 232 Hertzberg and then across 302 Leggett to the outlet. There is no need whatsoever to grant an easement in favor of 232 Hertzberg over the easement that's before you this evening. They simply do not need it, and it's not part of the application and never was.
Okay. Any questions from the committee on that? Got a chance to look at it? I'm looking at this tiny little box, part 1. And if that's what we're creating, it's completely within the lands to be retained. And I guess I'm missing the connection, Ms. Ramirez, between that and the benefit to, I guess, the lands on Hertzberg. Why, I guess I'm missing their connection, the rationale.
Staff's rationale for saying that it should include 232 Hertzberg was that the stormwater infrastructure goes from Leggett over 232 Hertzberg to 103 Schneider.
And that is correct. And the beneficiary of that is 103 Schneider, not 232 Hertzberg. That's why we created the easement. That's why we applied for and got approval for the easement over 232 Hertzberg in favor of 103. Now we're just getting the last piece for the outlet. But 232 Hertzberg is not benefiting from this easement that we're discussing this evening in any way, shape, or form.
Yeah, I have to agree, Mr. Chown. I'm not seeing it either. So, but then again, maybe I wasn't understanding it properly. But are there any questions from the members of the committee on that? Like, is everybody else clear on it? Okay, looks like everybody is, so that's great. In that case, we're not amending the notice to include 232 Hertzberg. Right, okay. All right. Anything else on that proposed easement? All right, not seeing any. We can go to the public portion on this. I believe I have nobody on the list. So is there anyone in the audience who would like to speak either for or against this consent application for an easement? All right, I'm not seeing anybody come forward. Going to leave it as proposed by the applicant. So ready for a vote? All those in favor? All right, so the application is unanimously granted, and I don't see anything that we need to discuss further. Just want to make sure there isn't anything missing. All right, so you only have one condition, and there's no issues with that?
There's no issues with the condition.
All right. Okay, well, in that case, I think we're done with your item. Thank you.
Thank you very much.
Thank you very much.
Chair, members of the committee.
All right, thank you. Okay, number 16 and 19 for 2865 East Walkley Road, looking for Mr. Leal.
Can you hear me?
Yes, we can hear you and we can see you. Good evening.
Good evening.
All right, need to read something to you, Mr. Leal. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear that to be true.
Perfect. We also have a bit of a housekeeping amendment to take care of on your application. We are, this would be on the minor variance portion. We are removing or deleting variance B, is that correct?
That's correct.
Okay, so for the record, we're doing that, and I don't see any additional information that we need to amend. Don't need a presentation this evening. Opening it up to the members of the committee for questions. Anyone? We've had so much discussion on this, folks. I can't believe you have no questions at this point from Mr. Leal on all this. I don't know whether we're worn down or we're just totally understand everything now.
I wonder if it's better to be earlier in the evening or later in the evening. I mean, it's a long wait, but now, yes, if you know, if it makes it easier, I'm all for that.
Oh, goodness. All right. I think we understand this. Am I understanding, Mr. Leal, that the city is going to support the road opening is there, and they're supporting moving forward with that? Is that correct?
That's correct. Well, what it actually, sorry, we found out the road allowance, which is we abut on the Hydro Road, which we have to do to be able to get this severance. The road allowance is actually open. It was always open. So what we're negotiating now, we've gone back and forth on the agreement, is actually the legal department has called it a road extension agreement, and it is just about the surfacing of the road in front of my client's property and up to the property lot line. That's the only thing it's about.
Okay, sounds like a good solution was brokered in any event.
Yes.
To make sure. Okay. That was it for me. I didn't really have anything else. Nope. All right, we're going to go to, do we have speakers for this? We have no speakers for this item. So I'm going to open it up to the public. Is there anyone in the audience that would like to speak for or against either the consent or the minor variance applications? Now's your chance. All right, I'm not seeing anybody come forward. So members of the committee, if you have no further questions or comments to make, then we can go to a vote.
Sorry.
Yes.
Madam Chair, are you voting now on the combined minor variance and the consent to severance?
No, we're doing the consent first and then the minor variance.
Thank you.
All right. So on the consent application, with the deletion, or sorry, no, just the, no, on the consent, back to the consent. On the consent application, I just want to make sure I'm looking at the right one here while I'm at it. All those in favor? All right, for the record, the application is unanimously granted. And on the requirement for minor variance, all those in favor? All right, so for the record, the application is unanimously granted. So I believe there's just a couple of conditions attached to the severance. Didn't hear any concerns, so we're going to assume that we're good.
Yep.
All right, well then with that, Mr. Leo, your applications are granted.
I feel like a very successful lawyer. I want to thank you all for your assistance on this.
Are we going to see you back on any of this? Just
Well, I know
let
you're
us know.
dying to. And if I can find something else wrong, it's not so much wrong, it's a difficult property. I sincerely hope not. Not that I don't enjoy this, but it's always a challenge when things don't go as planned.
Well, you know, if you come back, we'll save the best for last again.
Okay.
All right, thanks so much. Enjoy the rest of your evening.
Thank you very much.
All right, our last application for this evening, number 8. We're looking at 318 Mona Avenue, and I'm looking for Mr. Hamel. Do we still have Mr. Hamel? Good evening.
Good evening, panel members and the chair.
You haven't left us. You didn't decide just to throw in the towel for tonight, and that's it. It's getting too late. Okay. All right, I'm just going to need to read something to you, and I don't believe, yeah, we don't have anything. No statutory declaration. So, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I affirm that to be true.
Thank you very much. Housekeeping, little housekeeping item on your notice. To the legal description, we are going to add registered plan 238, City of Ottawa. Is that, can you confirm that?
238 registered plan. Let me just confirm, please, that that's the correct number. If it is, then we're good. That is correct. There should be a total of 14 parts.
Okay, sounds good. The rest doesn't need amendment. I think it's fine. All right, we do not need a presentation on the consent application. So I'm going to open it up to the members of the committee. Any questions for Mr. Hamel? No questions? All right, we're talking about separation of parcels of land to create ownership for proposed 2-story long semi-detached dwellings with secondary dwelling units.
Correct.
Okay. Can I just ask, oh, go ahead, Ms. Willis.
Just have a question for staff about the concerns on the tree canopy and the requirement for additional trees. Can we not just add that now as a condition?
Is there? Yeah.
Through you, Madam Chair, I believe we did add it as a condition, but since that time, they have in fact provided the tree planting plan, so we can remove the condition.
Okay, excellent.
So what condition is
Oh, number
that?
10, I see, number 10, yeah.
Okay. So we're deleting condition number 10, is that what I'm understanding?
I believe so. I'll check with Lucy to be sure, but I think that's where we left it the other day.
All right, Ms. Ramirez, can you just confirm?
Thank you, Madam Chair. Yes, staff submitted their report before the revised replacement plan was submitted, so that is correct.
And Ms. Young, no, you're fine with the recommendations of the tree information report that was submitted to you and the proposal?
I'm okay with it, I guess. It's not my preferred option, but given given the difficulty it would present to make enough changes to the house or the buildings to retain the existing trees, I think the alternative of replacing them with 6 new trees or 3 new trees each is the best we can do.
All right, and that is a condition, is it?
It was
here?
a condition, but in the interim between the submission of the report, they did provide an updated tree replacement plan, which had 6 trees in it. So we don't need the condition now.
How do we ensure implementation? I guess it's just, okay, all right, maybe that's just, as long as the condition is there, or it's not a condition. So the tree information report, I'm just trying to figure out the process then. So you have that, there's a proposal for 6 new trees. How do we ensure that happens?
Well, I mean, it would be tied to the decision, would it not? Like we have the plan, that's part of the approval.
All right, so that, and maybe that's the answer, is it's tied to the approved plan to include all of it, all of the site plan, including the trees. That must be it. Do you, Ms. Young, by the way, do you actually identify, so this tree planting plan has the trees, the 6 trees with the species and the caliper and all of that, right? So when you do your review, it's with all of that?
It has a general idea. It doesn't specify the exact species at this stage. It may change down the road, but it does give an idea of the size of tree and what's appropriate for the space. So I think this one is proposing 3 medium trees or 6 medium trees for the whole site. And I think that is appropriate for the space on the site. So they can choose from the list of species that are provided on the plan. That's not detailed, but yeah.
We're just learning as we go, so I appreciate that. Thank you. Ms. Ramirez, I see your hand is up, so go ahead, please.
Thank you, Madam Chair. I just wanted to note that the applicant submitted a revised draft for our plan with additional parts showing the walkways, and that amends the parts where that amends the parts that are identified in the easement request. So I have provided the information to the coordinator, but if the applicant doesn't have those parts to read into the record, I can read those parts into the record if required now.
Okay, Mr. Hamel. Mr. Hamel.
Yeah, I think, Lucy, were you there when the actual draft for our plan was identified as registered plan 238? The registered plan 238 shows all 14 parts. But if you want, I can read them in. I'm ready to do that if required.
I know that the registered reference plan that was omitted, that information was omitted from the legal description, but the draft for our plan is not registered to my knowledge.
It's not registered, but that's how it's identified to be registered.
Right.
Look, in an abundance of caution, I will read them in. Okay.
Go ahead, Mr. Hamel.
So, part 1 has also part 1 and part 14 are one lot, And part 14 benefits part 5 for walkways. Under the ownership of part 4, it includes part 13, which is a walkway to benefit part 11. In part 5, the smaller parts 2 and 6 benefits parts 1, 4, and 11 as a driveway.
Can I just interrupt you for a moment, Mr. Hamel? So I'm looking at the notice. And the notice, essentially, I guess I'm trying to figure out, are we deviating then from what's, and Ms. Ramirez, I guess I'm looking to you, because all of these parts and benefits thereof to other parts is clearly outlined in the notice. So are we amending this? And if we are, what are we amending it on the basis of?
So thank you for the question, Madam Chair. The initial design changed because it was initially not compliant with the secondary dwelling provisions, and the walkways weren't permitted to be next to the driveways, and so they were moved. And so the applicant is adding additional easements for those walkways to benefit the properties in the back. So part 1 and 14 are one property, and part 4 and part 13 are another property. And the walkways are shown on the amended 4R plan as part 14 and part 13. And those benefit the properties to the rear. I do have a, if you allow me, I took a look at the notice and look at the parts and match them up. And so I can read that portion into the record now if you would prefer.
Do you have that in writing that we can put on the screen so everybody can follow?
I did send it to the committee coordinator. I'm not sure if she can bring it up right now.
Perfect. Okay, that's what okay. Just a little bit, yeah, okay, that works. That works. I'll just have to move my box. This box, I find myself moving this silly box all over the place, so. All right, so it is proposed to create easements and rights of way for parts 2, 6, 7, and 8. So Mr. Hamel, I'm going to ask you just to confirm this when we get through this. For the benefit of parts 1, 3, 4, we're striking 8, we're adding 9, 10, 11, 12, and over part 3, striking 8, 9, and 10, 12 for the benefit of parts 1, 2, 4, 5, 6, and 7, and number 8. Does that seem to read correctly for you, Mr. Hamel?
Nope.
It does? Nope.
There are 2 parts missing. Can we, if I can ask the coordinator to go to our PowerPoint page 2, there's a chart there. So the chart on the right-hand side, we see the proposed lots, and then A, B, A plus B, C, D, C plus D. The ones that are important for us are A, B, C, D. So the brightly colored ones. Those parts there fully describe the property and the consents for those properties and the parts. And what I can do is identify what those are. A is lot 1, which is number 314. And lot 1, if you just slide up a little bit, yeah, lot 1 we can see as lot A, which is at the top left hand of the site plan there. And it's hatched in diagonal hatching in that peachy color. So lot A comprises lot 1 and part 14, which is to the left side of it. That part provides pedestrian access to lot B.
Right, so Mr. Hamel, I guess so we can go through all this, but at the end of the day, what I really want is I want to be able to identify which parts are, so for the easements, right? So it's the easements that we're really concerned about here.
Sure.
So we want to identify which easements over which parts for which benefiting parts. So that's the language that we really got to zero in on here.
And that's what I was, Madam Chair, slowly making my way through when I started describing these parts.
Okay, so let's walk through this in terms of the wording. So it is proposed to create easements and rights of ways over parts. All right, so what would you say then? Like, what are we changing? I'm just looking for, I'm trying to figure out what the revision is here.
Frankly, I don't know what we're changing because the numbers don't correspond to the latest set of plans that we've had prepared for the draft 4R.
Okay, but we're creating easements and rights of ways. All right, so over what parts is that happening?
I'm sorry, you faded out there a little bit.
So we're creating easements and rights of ways over parts. Okay, so now let's identify the parts.
Sure.
Parts.
Part A, if we refer to my drawing there, includes part 1 and part 14.
Okay,
Part
1, 14. Okay.
And part 14 comprise lot A.
We have an easement. I just want to make sure I'm following. So we have an easement over parts 1 and 14. And who's that to the benefit of?
No, there's an easement called part 14 over lot A to benefit lot B.
Okay, so.
And lot B is comprised of a whole bunch of parts. But on our drawing there, you can see lot B is the red diagonal hatched property, the pole-shaped property.
Okay. All right, at the end of the day, we're trying to replace this paragraph. And we really need to be able to do it pretty succinctly. So if we're creating,
I think part 13 and 14 are walkways that benefits parts 11 and 5 respectively.
So Ms. Ramirez, I see your hand is up.
So yes, thank you, Madam Chair. So there are two, I guess, easement text that I sent to the coordinator. The first text that she showed the amendments to the notice as existing. And then the second block of text that I sent her showed the amendment for the walkways. And Mr. Hamel is correct that they need a walkway over part 14. And then those parts that are identified as 2, 5, 6, 7, 8, that is for the lot in the back that Mr. Hamel was referring to.
So this is these are additional easements. I'm beginning to really become confused in all this. So the amended, yes. So the first one that we saw stands, am I correct? And then we're adding this as further description?
Yes, Madam Chair. The first block of text that we saw was the amendment that takes into account the additional parts that are shown on the draft reference plan, with the exception of part 14. It's I didn't reference part 14 in that first block of text, but the applicant has included additional parts for the bicycle parking. And so that first block of text that we saw was updating the notice that is currently, the easement request that is currently in the notice. And then this, the second block of text, this block that we're seeing on the screen right now is for the walkways.
And it's an addition of description. Yes. All right, I want to just be clear on that. So, okay. All right, so can we go back then to the first one? Let's get that one right. And then we'll come back to this one and get agreement on this one. So, and it sounds like we have an amendment to make to the first one to capture part 14, which is what I think Mr. Hamel was getting at.
That is correct.
Okay, so can we get that first piece back up? Are you confused, Mr. Hamel? Because it sounds like we're adding, right, a description for an easement, right?
Well, I don't know what the first one is. If the first one was parts 1 through, I don't know, about 9 or 10 that did not include the garbage, then the garbage, the two parts 8 and 12 should be added, and subsequent to that, parts 13 and 14.
All right, so this particular text speaks to just the pedestrian vehicular access. Not garbage, not parking, not any of that. So
that's correct. That's the first one, I guess.
right. So are the right for just pedestrian and vehicle access? Ms. Ramirez, anything missing from this?
No, I will note that the additional parts that were identified, I was thinking there for bicycle parking, but part 8 and 12, those would be the garbage enclosures that Mr. Hamel is talking to. So this is for the driveway and right of way, and then the garbage as well is that additional part that's been identified.
Should we be separating them out at this point?
Well, the garbage needs to make it to the curb, so I can understand including them in the first text.
All right. And is this the first text, or have we got a new one?
This is the second one. This is for.
Okay, let's get the first one back up. All right. So it is proposed to create an easement and rights of way. And what I'm not seeing here is where we see 8 and 12, which is the garbage enclosures. What about 14? Does 14 need to be in here?
Yes.
What's 14 for?
14 is the walkways, which is covered off by the second block of text.
All right. What's the difference between a pedestrian access and a walkway?
You could combine them all. The way that this approach that staff took was that this is amending the notice that was already, this was amending the text that's already in the notice, whereas the second block of text adds the walkway. So this is the driveways. This is the driveway down the middle of the lot.
All right. Okay. Are you okay with that approach, Mr. Hamel? That we tweak what's in the notice and then address the remainder in that second block of text?
Sure. Just so long as they're all in there at the end of the day.
All right. So let's do the second one up again, please. Because this would be the new description, part description.
Yeah.
All right. Staff note that additional easement right-of-way is required over parts 4. Is that a 14? For the benefit of part 2, 5, 6, 8 for this, which now I would say walkway access, because we're getting because now we've got pedestrian access before. So let's call this walkway if we could, just so that I'm a little more clear. Likewise, an additional easement right-of-way is required over part, and we're striking 13 for the benefit of parts 3, 9, 10, 11, 12. For again, I take it this is walkway stuff, Ms. Okay, so let's call it walkway access, and then the applicant should confirm the additional easement required. So what do you mean by that?
So this is staff's interpretation. So this is where I'm asking the applicant to confirm that I have it right.
All right. Does this read, knowing that we're going to swap out the word pedestrian for walkway, does this do it for you, Mr. Hamel? Because now what we've got is the pedestrian access covered and the vehicular access covered and the garbage enclosure covered under the first text. And then this one is to deal with the walkways.
So,
Yes, go ahead, please.
I guess I'm having, in an abundance of caution, to see if I'm reading this correctly, Ms. Ramirez, through the chair. Staff note that an additional easement / right-of-way is required over part 14 for the benefits of 2, 5, 6, 7, 8. Am I reading your numbers correctly?
Yes.
Okay, so it's not part 1 and then 4 with a red 4 and underline. That's one number, 14. Okay.
Yes.
Thank you. I think it looks pretty good.
All right. So, all right, we're going to go with the changes then in that we just talked about for the record, but I'm going to ask you to just maybe confirm this with yourselves tomorrow to be absolutely sure that we've got the right numbers in here. I think we understand what we're trying to achieve without walking part by part, just to be absolute. I'd rather that exercise happen. If you feel you need that comfort, do it tomorrow. And if there's any change required, make sure that you let committee staff know. But I guess for the purposes of moving forward tonight with understanding the intent and purpose of these easements, we can work with this.
Okay, I'm thinking.
Okay. All right, I just want to hear from my committee members. So does anybody on the committee want to ask any questions or throw any darts at any of this? No? Okay, all right. In that case, that's great. I think that ends the changes that we need to make then. All right, and did I ask the committee members whether or not you had any questions for Mr. Hamel at this point? Anything you want to learn a little bit more about? It looks like an interesting project, I'll be honest with you. It looks like a good densification of land. So, and well done, well designed. So I'm going to go to my list, and I do have people. I do have someone actually. 2 people. I do have 2 people. So I'm looking for Maria, and I think it's Chiquino and Casey McLean. And I'm sure Cinquino. I think, okay, that's not exactly what I have, but it's okay. Do we have our speakers?
Oh, yeah.
Good evening. Good evening. And thank you so much for remaining online with us this evening. There has to be somebody who's last, and we really appreciate you're taking the time to stick with us and to come and speak with us. So with that, go ahead.
Oh,
and
we're the owners of the property, so we just want to say thank you to Mrs. Ramirez and Mrs. Young for working with us, and thank you to Jacques and Rachel for preparing this and getting this to the Committee of Adjustment. Thank you very much.
All right. Okay. So you're speaking in support.
Yes. Yes. We are.
All right. Okay. I wasn't sure. I didn't. Oh, yeah. Okay. No, I do have that. It's the owners. Okay. Sorry about that, but thought I'd give you a chance. Anyway, I don't have anybody else on my list. So is there anyone in the audience who'd like to speak either for or against this application? Now's your chance. Just out of curiosity, coordinator, do we have anybody left?
Nobody is online.
Nobody's online. Okay, so that's the answer. There's nobody left. Okay, so with that then, committee members, I think we can move forward based on some of the amendments that we've made with a vote on this. Mr. Hamel, before we vote, any questions on the conditions?
No, we did read through them and they seemed pretty straightforward. Thank you.
Okay, excellent. All right, then, members of the committee, all those in favor of this application. All right, so everyone is in agreement and in consensus for the record that we are approving the consent application for the creation of 4 separate parcels of land to allow for 2 long semis and secondary dwelling units. So it'll be really interesting. This is one I'd actually love to see once it's done. Any chance we can get a tour? It'd be nice to see how these things actually work out, to be honest with you, you know? The city's promoting this kind of development, so it would be interesting. Anyway, just a thought. Okay, all right.
Have a good
Go ahead.
evening.
All right, have a good evening, and again, thanks for sticking in there with us. It is late. So, for the rest of the members of the committee, need to adjourn the meeting. So all those, or I guess I need a vote, but I need the gallery view. Is it possible to get the gallery view back? Why don't I have the gallery view? That is really weird. Okay, never mind. All right, so back to a motion to adjourn. Mr. Okay, thank you, because the only 2 people I can see to be on. Now I see Julia, so I'm actually going to go with Julia. So Ms. Markovich moves and seconded by Mr. Hindle. So the meeting is adjourned, and as usual, I'd like to thank staff for all of your support this evening, both